Yes, on the list.
Inclusion in your lawsuit is itself a withdrawn application and it's appropriate for that purpose. For filing paper,
I will be permitted to mention on 23rd of June, my lord was pleased to take up my 2 applications for stay, but one of which was it is not yet served, my lord. The 28th is a day fixed for last date for deposit of the awarded amount before this court, my lord.
It was not served.
One is not yet served, my lord. If my lord kindly directs my lord officers.
Give me the number. This number.
My lord, I have given.
Definitely দেখো তো।
Lordship, may I please permitted to mention, Lordship, my matter, Lordship, yesterday, the matter came before Lordship as item number 13. I was not in a position to appear before the Lordship. My clerk through the one of the advocate print and not today. And Lordship sent it to the August month, please. Lordship, kindly take it any day, Lordship.
August month, please.
Yes. I am for the claimant, Lordship. I am suffering for.
Yes, one person is there. Someone is there to move like that.
Any day, Lordship.
No, who are you? You are.
I am for the claimant respondent, Lordship. I am suffering, Lordship. In the year of 11, Lordship, award was passed.
Claimant respondent.
Yes. Track owner filed the appeal, Lordship. Due to that reason, it is dragging, Lordship. And direction was given to the insurance company.
But the appellant submitted that they are suffering some treatment in the Vellore. Like that.
2012, the appeal
No,
was filed.
I do not know. I don't know. The appellant who moved before me that their treatment is going on like that.
No, this is a false submission that may be, Lordship. 2012 appeal was filed on 2012, Lordship. Direction was given to the insurance company to prepare the check and 4th check, Lordship, in favor of the 4th claimant, wife and 3 sons. And direction was also given to the insurance company to recover the money from the truck owner. Due to that reason, the appeal was filed.
Okay, tomorrow you come on mentioning after service.
Yes.
That would be better.
Yes, I will come.
My lord, this is for inclusion of an application, my lord.
75.
Okay, you come after service tomorrow.
Lordship, I will come.
My lord, inclusion, my lord, of an application, my lord, in respect of a cross objection.
Well, if I made it 2006, my lord, paper book already ready, my lord. I am for the respondent case. And defendant is for.
Yes, Mr. Singh.
Lordship, yeah. Lord, this is the appeal of insurance company.
Yes.
Lord, this is a death case under section 166. Lord, in this case, in the year 2010, Lord, one gentleman, Lord, one Mr. Deepak Jana, while riding a motorcycle, Lord, he collided with a truck. It was a head-on collision. Right? The person who was riding or driving the motorcycle, Mr. Jana, he died in the accident. Lord, learned tribunal judge, Lord, passed an award of rupees 23,26,364. 23 lakhs order. Lord, pursuant to the direction of this honorable court, Lord, I have secured the entire awarded amount before my lord's court, Lord, along with the interest, whatever was granted. Lord, initially I deposited the statutory amount of 25,000.
Yes.
Lord, thereafter, Lord, 30,91,485 was the subsequent deposit.
Yes.
Lord, the money is lying before my lord's court, Lord, is earning interest. Now,
Yes.
Lord, I have come up with your lordship, Lord, on 2 grounds. Lord, first was the contributory negligence of the victim. Lord, my client takes a plea
Yes.
that the deceased motorcyclist, while driving or riding that motorcycle,
was himself responsible for the said accident. He himself contributed to the said accident, and in a proceeding under section 166, since it's signed up for non proving of rash and negligent driving. So, to the percentage what deceased himself was negligible, that percentage has to be deducted, whether it is 10%, 50%, 100%, whatever. It is not the case that there is no entitlement. The case is compensation is to be assessed, and then the percentage of negligence of the victim has to be found out. Percentage of negligence of the victim has to be found out, and that percentage from the total company. I'll show authorities to your lordship, to make it easier for my law. That percentage has to be deducted. For example, if compensation of 100 rupees is assessed, taking care of everything, and then it is found that victim was himself negligible to the extent of 25%. So, that 25% of that 100 rupees is to be deducted for his own contribution negligence, and the balance 75 to be given. Assuming the same line, if it is found that he was negligent to the extent of 80%, then 80% is to be deducted and balance 20% is to be given to the claimants. This is the principle of law. I'll show it to your lordship. This was the first point, that the contributing negligence has to be assessed. Nalne tribunal judge did not assess any contributing negligence. Nalne tribunal judge decided that no entire fault or liability or wrongdoing or responsibility of the accident was of the truck driver. My client is the insurance company of the truck driver, so entire liability of payment was left upon my shoulder. That was the first point. Second point is on quantum. On quantum, I do not have a very good footing, because at one point of time, there was a concept of a split multiplier. A couple of division benches of this honorable court, the honorable judges, while deciding the multiplier, they took note of the fact that how many years of, in the case of service holders, victim being service holders, how many years of service is left?
Yes.
That leftover period or the residual period of service was taken into consideration for selection of multiplier. In this case, to be specific, deceased was 54 plus years old. Let's say 54, 55. His service was 5 years or 6 years was left over service, because 60 was the age of retirement. That is their own record. So, at that point of time when this appeal was filed, as I stated, honorable division benches of this honorable High Court, in a number of cases, they had decided that leftover years, as I said, is to be taken into consideration for selection of multiplier. I had taken that point also. The learned tribunal judge, has applied the multiplier, of 11 in this case.
Yes.
I took the plea before your lordship, that no, it should not be 11 or 12, it should be 6, because 6 years service has been left. But now with Pranay Sethi, which is affirming Salla Verma, and the scores of other judgments, that issue has been settled. So I will not be troubling your lordship on this issue of a split multiplier, or for selection of multiplier for the residual years of service.
Yes.
So, on quantum, I would not be troubling your lordship. That's what the second point, I give up. Your lordship will not record my statement.
Yes.
Not record my concession. But, that is not to be troubled to your lordship.
Regarding contributor negligence.
Regarding contributing negligence, I come. Do I take your lordship, to the award first, so that now then in the context of the award, your lordship can see, the evidence produced. My lord will, be kind enough, to come to page number 64. May I read, page 64, my lord has got it,
Yes.
This is an application under 166 of Motor Vehicle Act filed by the petitioners, paying for compensation of 30 lakhs, along with interest and litigation cost on account of death of Deepak Jana, who died in a road accident on 23rd November 2010. According to claim application, on so and so at about 7 p.m., the victim was going from Moina side towards Balichak through Moina Balichak road by riding motorcycle, following the left side of the road. when the deceased reached near village Chandras Chowk under Moina police station, at that time, one truck bearing registration number so and so, I am insurance company of this truck, dashed the motorcycle of the deceased in a rash and negligent manner in violation of the traffic rules, and as a result of the accident, victim fell down on the road, sustained severe injury on his head, and died at the spot. The alleged accident occurred due to rash and negligent driving on the part of the driver of the offending truck. Victim was the only earning member of his family, and he was a school teacher. At the relevant point of time, he used to earn rupees 31,900 per month. At the time of alleged accident, victim was 54 years. Petitioners, being the wife and children of the deceased, have filed the instant application against one Gautam Shingo and Kaushik Pradhan, the owners of the offending vehicle, and the insurance company being the insurer of the said vehicle.
Yes.
Owners did not turn up to contest the case. As such, the case proceeded ex parte against them. Page 65. The opposite party insurance company contested the case by filing written statement wherein the maintainability of the instant case has been challenged in various ways. The opposite party insurer has denied its liability to pay compensation as claimed by the petitioners in its written statement. Opposite party has specifically stated that alleged accident never occurred due to rash and negligent driving on the part of the driver of the vehicle bearing the registration number 7. Lord, should we take note of this?
Yes.
Specific pleading, I'll show that. Learned Tribunal has taken note of this. Upon the above pleadings and the following issues were framed by my learned predecessor in office.
Yes.
Issues are there 1, 2, 3, 4, 5. Issue number 2, is relevant. Whether the injury of the victim was caused related to the death
Yes.
was caused due to rash and negligent driving by the driver of the offending vehicle bearing number so and so. In order to prove their case, the petitioners examined 3 witnesses and relied upon exhibits 1 to 12. The insurance company examined 2 witnesses.
Yes.
Decision. For the sake of brevity and convenience, all the issues are taken up together for consideration as they are interlinked to each other. PW1, Srimati Navonita Jana, is the wife of the deceased. During her examination in chief, she stated that on 23rd November 10, at about 7 p.m., her husband Deepak Jana met with an accident near so-and-so under Moina police station. And at the relevant point of time, her husband was going from Moina side to Pingla side by riding his motorcycle, keeping the left portion of the road, and the offending truck bearing registration number so-and-so, which was coming from Pingla side, with high speed, dashed her husband with great force in a rash and negligent manner. And as a result, her husband fell down on the road and sustained grievous bleeding injury on his head and died at the spot. From the cross-examination of PW1, it appears that PW1 was not present at the time of alleged accident. PW2, he is the person. Vishwajit Kaur is an eyewitness to the occurrence. From his deposition, it appears that on 23rd November 10, at about 7 p.m., while he was proceeding to Jalsak side by riding his cycle, he found deceased Deepak Jana was going by Pingla by riding a motorcycle bearing registration number so-and-so from Moina side, keeping left side of the road, and he found one truck bearing registration number so-and-so, which was coming from Pingla side with high speed, dashed the victim with a great force. As a result, the motorcycle of the victim was totally damaged and he sustained severe bleeding injury on his head, and within a moment he died at the spot. It has been specifically stated by PW2 that the alleged accident occurred due to rash and negligent driving on the part of the driver of the offending vehicle bearing registration number so-and-so. That is of the truck.
Yes.
The evidence of PW2 regarding the accidental death of the deceased due to the rash and negligent driving on the part of the driver of the offending vehicle remains unshaken in spite of his cross-examination. Exhibit number 1, that is the FIR. Number 2, charge sheet. 3 and 3A's result list shows that FIR was lodged over the accident, and after completion of investigation, police submitted charge sheet. Exhibit 4 is the post-mortem report, which shows that deceased died due to head injury. In this connection, learned advocate for the opposite party number 2 submitted that in the instant case, no reliance can be given on the evidence adduced by the petitioners regarding the accidental death of the deceased, resulting the rash and negligent driving on the part of the offending vehicle. In support of his contention, he has drawn the attention of evidence of OPW2, Noru Gopal Panda. Learned advocate for the OP number 2 has submitted that OPW2 Noru Gopal Panda is the driver of the offending truck bearing registration number so-and-so, and from his evidence, it cannot be said that the alleged accident occurred due to rash and negligent driving on the part of the driver of the offending vehicle. Honorable, take a note of this also.
So driver appeal.
Lordship. I'm grateful to you.
Yes.
In the instant case, the opposite party number 2 has examined one Noru Gopal Panda, against whom police submitted charge sheet. After completion of investigation of the alleged accident, for commission of alleged offence punishable under section so and so. That means OP number 3 is an accused of the case initiated after the accidental death of deceased Deepak Jana. And after completion of investigation, police submitted charge sheet against him. The said accused was examined by OP number 3 on dock. In his examination in chief before the court, he stated that one motorcycle dashed his truck on 23rd November at about 6:30 p.m. and he was not responsible for the accident. From his evidence, it appears that after seeing the motorcycle, OP number 3, that is the driver of the truck, tried to cover the left side of the road. And at that time, he noticed that the bike came towards his left side. And the driver of the bike drove the bike with the help of his left hand. And his right hand was in his pocket. And he was trying to take out something from his pocket with the help of his right hand. And as such, the accident occurred due to the fault of the driver of the bike. The OP number 2 has been produced to prove that the alleged accident occurred due to the fault on the part of the deceased. He is an accused of the alleged accident. He is an interested witness. The evidence of OP number 2 cannot be said to be independent. An accused always tries to prove his innocence by blaming others. In the instant case, the evidence of OP number 2, against whom charge sheet was submitted for commission of offence under section so and so for the death of the deceased, cannot be accepted at all. In the instant case, the petitioner produced one independent eyewitness, wherefrom it appears that the alleged accident occurred due to rash and negligent driving on the part of the driver of the vehicle. That is OPW number 2. The evidence of PW2, coupled with exhibits 1, 2, 3 series and 4, it can be safely held that accident occurred due to rash and negligent driving on the part of the driver of the offending vehicle, bearing registration number, truck number, so and so. Exhibit 5 is the copy of insurance policy, wherefrom it appears that at the relevant point of time, the offending vehicle was registered against opposite party. In the instant case, the petitioners claim that the victim died at the age of 54 years. Exhibit 6 is the original certificate of higher secondary examination of deceased Deepak Kumar Jana. From the exhibit, it appears that his date of birth was 28 June 56. The alleged accident occurred on 23/11/10. That means at the time of commission of accident, the deceased was 54 years, but less than 55 years. In this connection, the learned advocate for the claimants petitioners has submitted that in between the age group of 50 to 55, the usual multiplier is 11. Learned advocate for the opposite party number 3 has submitted in the instant case. The multiplier would be 6 instead of 11, as the deceased was a school teacher and he was due to retire from his service at the age of 60 years. In support of above contention, learned advocate for the insurer has placed his reliance on a decision reported in so and so Calcutta. The learned advocate for the petitioner has drawn the attention of the court to the second schedule appended to the Motor Vehicles Act and submitted that in case of death of 54 years, the multiplier will be 11, and the tribunal is under an obligation to follow second schedule appended to Motor Vehicles Act. In support of his contention, the learned advocate for the petitioner placed his reliance on the decision of reported in so and so Calcutta, so and so Supreme. Both these contentions are wrong because after Sallah Verma and City, the schedule what has been made, that has to be accepted. I've gone to the decision so cited at bar. The decision cited by the learned advocate for the opposite party number 3, reported in Calcutta, Honorable Division Bench of Calcutta High Court opined that since the victim had income of rupees 11,000 a month, the second schedule of Motor Vehicle Act in terms could not apply, and therefore there was no scope of applying the multiplier as provided in the second schedule. In view of the Honorable Division Bench, the victim being an employee of the state of West Bengal, and when it has been established from the record that he was due to retire at the age of 60 years, the Honorable Court did not find any illegality on the part of tribunal below in applying the multiplier of 6. The decision reported in so and so Calcutta Division Bench of Honorable High Court observed that the victim was an employee of Durgapur Steel Plant and was in a stable service with future prospect and was aged between 50 to 55 years. Then there is no reason why the same multiplier should not be applied when the claimants have proved that the bus owned by the appellant due to rash and negligent driving, the appellant killed the victim. Both the judgments of Honorable Court have been passed by the same bench. This is Calcutta High Court. In the case cited by learned advocate for the opposite party number 2, the multiplier was taken as 6, and the decision given by the same bench as cited by the claimants petitioners, the multiplier was taken as 11, though the age group of both the victims were between 50 and 55 years. In another decision reported in 2013, Supreme Court, Honorable Supreme Court has been pleased to observe that the standard method for selection of multiplier is surely better than a crisscross of varying methods. Honorable Supreme Court has been pleased to hold that they accept the age of victim up to 15 years, multiplier as indicated in column 4 of the table as given in Sarla Verma's case should be followed in all other cases. From paragraph 27 of that judgment, it appears that between the age group of 50-55, multiplier is 11. No, that has been adopted. Yes. I do not contest this. I give it up. In view of the above, I am of the opinion that it would be reasonable and justified to adopt a multiplier 11 instead of 6 as claimed by the insurance company. In their claim petition, the petitioners have claimed that the deceased was an assistant teacher and used to earn rupees 31,900 per month. In this connection, learned advocate for the opposite party number 3 has submitted that the income of the deceased should be assessed after deducting income tax for the relevant period, the standard deduction, and 1/3 deduction towards his personal expenses. In this connection, the learned advocate for the petitioner submitted that percentage of deduction on account of personal expenses may vary with reference to the number of members of dependent. According to his submission, the number of dependent family members of the deceased is 4. As such, the question of deduction of 1/3 towards the personal expenses of the deceased would not be reasonable and justified in the instant case. In support of his contention, the learned advocate for the petitioners has cited another decision reported in 2013 Supreme Court and has contended that in the instant case, the deduction towards personal expenses of the deceased would be 1/4 instead of 1/3 as the number of dependent family members is more than 3. In order to prove the income of the deceased, that has been adopted. 1/4 has been deducted.
Yes.
I do not dispute that. In order to prove the income of the deceased, the petitioner examined PW3. PW3 is the headmaster of Kirul High School, Pushti Medinipur. From his evidence, it appears that the salary of the deceased was 30,900. And after deduction, his net salary was 29,252. During his cross-examination, PW3 has admitted that the net salary, as shown his acquittance roll for the month of October 2010, does not show the deduction of income tax, as there was no such system for deduction of TDS at the rate of 20% from gross salary. He has admitted that this was an income tax paid. This was an income tax, this is an admission. PW3 could not say how much was paid as income tax from the income of the deceased. From acquittance roll of the teacher for the month of October 2010, it appears that the gross salary of the deceased was 30,902, and after deduction of professional tax 150 and deduction of PF of 1,500, his net salary was 29,252. In the instant case, no iota of document has been produced on behalf of the petitioners regarding the amount of income tax paid by the deceased. In the above situation, I have no other alternative but to reduce 20% from the net income as income tax. After deduction of 1/4 towards his personal expenses, as the member of dependent members are 4, comes to 17,552 per month. Thus, the annual contribution of the deceased towards his family would be 17,552 into 12, that is 2,10,000 odd. After applying the multiplier of 11, the total compensation comes to rupees 2,10,000 into 11 is equal to 23 lakhs. Amount of compensation includes loss of consortium, loss of estate and funeral expenses. As such, another sum of 9,500 may be added to the said amount of compensation. As such, total amount of compensation comes to rupees 23 lakhs odd. Amount of compensation includes interest, and as such, petitioners are entitled to get interest at the rate of 9% per annum from the date of filing of claim application till deposit is made. Excessive interest is there, Lordship will kindly decide while we are deciding the appeal. Then issues are disposed of. Last page, page 71, order, claim application 166, allowed on contest. I will not read further. There was a minor, so the minor was taken care of. The money was to be given to the mother, who was to deposit it in the Nationalized Bank. This is
the issue.
This is the issue.
Learned Tribunal has not considered the OPW2, the driver, on the ground that
He was an interested
witness and criminal case is pending.
Lordship.
Charge sheet has been
filed
against him.
Lordship.
So how his statement can be given
My
on this ground? So what is your submission on
Lord, what is this case? In 166, I need not trouble your Lordship. And at the cost of repetition, I say, my Lord, the rash and negligent driving of the driver of the offending vehicle is sine qua non to claim compensation. The claimants have come up before the learned court, wherein they state, Miller, that the driver of the truck was solely responsible for the accident. Once you, Miller, make allegation against somebody, you prove that. To prove that, Miller, you have brought one witness. That witness-
PW2.
PW2. I'm good. Let's see the evidence of PW2. Before that, I'll just take your lordship to the written statement of the insurance company, whether the insurance company has taken it in the pleadings or not.
Yes, it
In
is
order to-
taken in the pleading, judgment is also stated.
Lordship, just for my satisfaction, at page
Yes.
number 10, if my lord kindly comes to me. This
Page
is
number 10.
page number 10, this is the continuation of the written statement. Written statement starts at page number 6. I'm inviting your lordship, to page number 10, which starts at paragraph 24.
Yes.
My lord has got it, Miller? That this opposite party denies liability to pay compensation as claimed. Rather, it is submitted here that the alleged accident never happened due to any rash or negligent driving on the part of the driver of the alleged truck. As such, this opposite party insurance company is not at all liable to pay any compensation as claimed for the reason that the stated accident has been caused due to the sole contribution of the victim himself, being the motorcyclist.
Motorcyclist.
So, Miller, this is the specific pleading made. Now, law, Miller, let's see the evidence of PW2. The sole eyewitness on the basis of which this entire case has been made. Miller, this evidence, your lordship will kindly come to page number 16, 16. My lord has got it, Miller, page
Yes.
16. What may I read? This is the chief. I'm the eyewitness of this claim case. That on 23/11/10 at about 7 p.m. while I was proceeding to Jalchak site by riding my cycle, I saw deceased Deepak Kumar Jana while going to Pingla site by riding a motorcycle bearing number so and so from Moina side. He was proceeding smoothly, keeping his left side of the road. Just after leaving me, he was going about 100 meters distance from me. I saw one truck bearing number so and so, which was coming from Pingla side with terrific high speed, endangering to human life and safety, dashed the victim along with his motorcycle in a great force. Not pausing here for a moment. This witness, he was going on a bicycle. The deceased motorcyclist, he was coming from behind. He went past this bicyclist. Overtake. This gentleman, evidence says, that he was going from the left side, very nicely driven. Unfortunately, the accident happens 100 meters away. Your lordship perhaps knows the distance of 100 meters. If I stand here, we have ran those 100-meter races in our school days, maybe not after growing up. High Court finishes, the Kiran Sankar Roy Road starts, that is 100-meter, if we start 100-meter run from here. So this Vishwajit Kaur looks at a vehicle which is standing at Kiran Sankar Roy. 7 p.m. at night. Makes it out going on that vehicle is coming in a zigzag manner. There are no lights there. I'll show that also. And then it hits the motorcyclist. You will kindly see the stretch of imagination. I'll proceed further.
Yes.
I'll just read that line again. Just after leaving me, he was going about 100 meters distance from me. I saw one truck being number so and so, which was coming from Pingla side with terrific high speed. He could measure the speed also.
Yes.
Endangering to human life and safety, dashed the victim along with his motorcycle in great force. Why that truck did not hit you, this gentleman, bicyclist? As a result, victim's motorcycle was fully broken and victim sustained severe blood injury on his head, and after little moment he died on the spot. The accident was caused due to rash and negligent driving on the part of the driver of the offending vehicle bearing number so truck. I have seen the accident in a very little distance. I also examined by investigating officer of the Moina station. Milord, page number 18 is the examination in chief, Milord, was affirmed in witness box and thereafter cross-examination. Milord, I pray before your lordship to go through the cross-examination. I am a school teacher. On the relevant date, I was proceeding towards Jalchok as my residence is situated at Rasikpur. I was returning home from my school. My school is situated at Devondi. Distance in between the place of occurrence and the school is about 6 miles. On that day, our school was open. On the relevant date, the school was closed at 4 p.m. It was dark.
Yes,
But I am not bringing out anything from the thin air. Specific evidence. It was dark. There was no light fitted with my cycle.
yes,
And then, Milord, he tries to cover it up. Volunteers, I had a torch. So from that torch, he could see the vehicle at Kiran Shankar Rai Road standing here, which was coming in a zigzag manner when it was absolutely dark.
yes,
The accident occurred 1 minute and some moment after crossing my cycle by the motorcycle. At least, Milord, I am thankful that here he was truthful. 1 minute is, Milord, 60 seconds.
yes,
60 seconds, motorcycle, Milord, went past him. So that distance is correct. 60 seconds, Milord, on an empty road, motorcycle will go from here and it will reach Kiran Shankar.
1 kilometer. Yes,
Or Milord, whatever that is, Milord, that 100 meter or whatever. It is that at least that part is correct, Milord. 1 minute, Milord, Doctor will kindly visualize, Milord. 1 minute after that motorcycle left him, 7 p.m. at the dark when there are no lights, and then it meets with an accident. And then this gentleman comes up and says that, yes, I know that truck driver was coming in a zigzag manner in a rash and negligent driving. And then it hit the motorcycle. There was no fault of motorcycles. From this distance, he's making it up. Lord, I go further. The motorcycle and the vehicle both had light. At the relevant point of time, I could understand the speed of the offending vehicle. After the accident, when I reached the place of occurrence, I noticed 3-4 persons there. When the motorcycle crossed me, I did not notice the person on the motorcycle. Motorcycle crossed me, leaving 1.5 to, what is cubics distance on my right side. At that time, the motorcycle was on metal portion of the road. Not a fact that the accident occurred due to the fault on the part of the driver of the motorcycle. Not a fact that the driver of the offending vehicle was not responsible for the accident. I have not received any summons to depose today. I was requested by Nagunita Jana, the widow, the wife of the victim, to depose. I was not acquainted with Deepak Jana, that the deceased during his lifetime. I myself did not inform the accident to the police station. Not a fact that I myself did not see the occurrence. In the context of this evidence, because this is the only thing before the court, to decide the quantum of rash and negligent driving. And on this basis, 100% rash and negligent driving of that truck driver has been decided, which has got no value at all. In the facts and circumstances, 100 meters at night, you could not make out anything. I mean, this is not the city area.
yes.
Milord, I am not troubling your lordship, Milord, with this evidence of the widow, because the point, Milord, what I am trying to think before your lordship, Milord, it has got nothing to the evidence of widow, because Milord, widow, she was not there at the spot,
Yes.
she could not say anything. And, Milord, I am not on any other point, Milord, because I am supporting the judgment on other issues, same and except that interest point.
What is the evidence of the truck driver?
Lordship, I am obliged to Milord. Milord, page 25. My lord is at page 25.
Yes.
Lord, I am the driver. Noru Gopal Panda. I used to drive truck. My lord is there, my lord? On 23rd November 10 at about 6:30 p.m. one motorcycle dashed my truck. Lordship can one motorcycle dashed my truck. I was not responsible for that accident. After seeing the motorcycle running towards me, I tried to cover the left side of the road. At that time, I noticed that the bike came towards the left side and the driver of the bike was driving the bike with the help of his left hand, and right hand was in his pocket, and he was trying to take out something from his pocket with the help of his right hand. The accident occurred due to the fault of the driver of the bike. Not the cross-examination. Charge sheet was submitted against me by Moina police station. I cannot recollect as to whether I applied for reinvestigation before the court, as the submission of charge sheet against me was not proper. Not a fact that accident occurred due to my fault. Not a fact that I was forced. Nothing. A big zero. This evidence, which is so specific, so clear, nothing in cross-examination, is set aside. That you were driving the vehicle, you were charged it. But if he will not be charged it, who will be charged it? The deceased. He's already gone. And if you have charged it, then you take him into the cross-examination. He's there in the witness box. He's very specific. And you are relying upon an evidence which is 100 meters away from you, 7 o'clock at night, with no lights on the road. And you know everything. Well, in so many cases, the arguments are put forward before your lordship. Every second case, I would rather say, the driver is the best witness. My learned friend is appearing on behalf of the claimants. Maybe in the next case again, he would argue the same thing. Driver is the best witness. Insurance company never brought the driver to bring the truth. In numerous cases, starting from Mita Samanto, mother judgment for the claimants of
Yes.
this honorable court. Mita Samanto, every case, Mita Samanto. Mita Samanto says that bring the driver. Since you did not bring the driver, we presume that it was his fault. Here is the driver. This is in accordance with Mita Samanto. This is what Supreme Court had said. Mita Samanto followed. It followed earlier judgment, the career path of this honorable court, to bring your best evidence. Now the best evidence is before the court. Best evidence, which cannot be tarnished. He stood the vigor of cross-examination. He replied everything. Now, to wriggle out of this, if I may use the term wriggle out, with greatest of respect to the honorable judge, he says, I will go back to charge sheet. What is charge sheet, What evidence it has? What evidentiary value it has, in a civil court? Again, I take the same plea, what the claimants say. The finding of the criminal court will not have any bearing on the civil court. This argument, comes to your lordship in every second.
Yes.
Charge sheet is a prima facie evidence. He has not been proven guilty. And in spite, I go a step further, even if it is. In civil proceeding, he comes up before the court, he makes himself available before the learned tribunal judge. He gives answer to the question, and he is very, very specific. He doesn't evade. He gives that what has actually happened. He narrates the things. He cannot be struck aside. In the context of this evidence, your lordship, in my lord's inquisitorial jurisdiction, my lord act provides that the learned tribunal judge or the honorable high court should get into the matter. See to it, as far as the factual aspects are concerned. Law comes later. Law can be blind, but it cannot be devoid of common sense. When the facts are narrated so clearly before the learned court, then learned court turns a blind eye, and is leaving aside common sense at the side. This should not be. Here, at least in this case, in so many other cases, we do not take the plea of contributing negligence. Because one eyewitness comes in, there is no driver, Mita Samanto is on my face. No. Then my lord says, Mr. Singh, you did not bring any evidence. Here I have brought the evidence. My evidence is absolutely specific on the point. It cannot be brushed aside. They had all the opportunity. Now, my lord, I'll produce judgment. May I start with Mita Samanta, that particular paragraph?
Yes.
My lord, I've seen it obtained times, at the cost of repetition. Lord, kindly pardon me, but give me 1 second. Mita Samanta. The mother judgment. My lord, paragraph 16, your lordship has seen, my lord, so many times. Lordship will kindly come once again. It's small on the point of evidence to be produced. The paragraph 16, my lord, is there. The opposite principle applies with greater force when a party event does not dispute the statement made in the pleading of the other side and decides to remain ex parte. We are quite conscious that in the proceedings for compensation under the Motor Vehicles Act, when the offending vehicle is insured, the owner of the vehicle may not be interested to appear at the witness box in spite of the fact that he is a party to the proceeding. This is what happens, and my lord knows that. For that reason, the legislature has incorporated the provision contained in section 170 of the Act, permitting the insurance company to contest the proceedings on all points. Once such leave is granted, it is the duty of the insurance company to summon the owner of the vehicle to appear as a witness for disputing the allegation of the claimants. If the insurance company, after taking leave of the tribunal under 170, decides not to lead any evidence by summoning the relevant witnesses, including the party whose liability it has undertaken, its position in law will be just like the party who is afraid of appearing in the witness box to face the cross-examination of the claimants. It is preposterous to suggest that the court will hold against the claimants, notwithstanding the fact that in spite of the allegation of rashness and negligence against the driver or the owner of the vehicle is deliberately avoiding the court, and the claimants are unable to cross-examine the owner against whom the compensation is claimed, or the errant driver whose identity has been disclosed in a civil proceeding. This is what the advantage is taken off by the claimants. This paragraph not further elaborates, but this is where every time it falls back on this. Yes, they did not bring. Here, before my lord, the person is appearing.
OPW1 is the owner.
Lordship. No, my lord. PW1, my lord, is the veto.
No, who is OPW1?
My lord, OPW1, my lord, is the officer of the insurance company.
Officer of the insurance.
Lordship.
Okay. Very well. Please continue.
So, my lord, the driver came. The driver gave evidence. Evidence is not shaken, and that is in compliance of the judgment of Mita Samanta. That yes, you have not avoided your responsibility. You brought the person in the witness box. You made him appear for cross-examination before the claim, and he was unshaken.
Yes.
Just for my satisfaction, this issue of contributing negligence, so that it is not mixed up with composite negligence. I'll just show one paragraph of a judgment, which is well settled. Your lordship is aware of this, but just one judgment, just to give distinction between the composite negligence and contributing negligence. When I started my argument, by illustration, I made it clear before your lordship what is a contributing negligence, how the assessment is to be made, and how the percentage of the contributed negligence has to be deducted from the total compensation. This Supreme Court judgment This is one of the original judgments. It follows certain judgments. Subsequently, it has been followed in various judgments. Paragraph 6, I'll invite your lordship to. Paragraph 6 and 7. Citation is 2000 Supreme Court AIR 2008 Supreme Court 2851. Paragraph 7. If my lord will kindly come to me.
Yes.
To determine the question as to who contributed to the happening of the accident, it becomes relevant to ascertain who was driving his vehicle negligently and rashly. And in case both were so doing, who were more responsible for the accident and who of the two had the last opportunity to avoid the accident. In the case the damages are to be apportioned, it must be found that the plaintiff's fault was one of the causes of the damage, and once that condition is fulfilled, the damages have to be apportioned according to the apportioned share of responsibility. If the negligence on the plaintiff's part has also contributed to damage, this cannot be ignored in assessing the damages. He can be found guilty of contributory negligence if he ought to have foreseen that if he did not act as a reasoned man, he might be hit himself, and he must take into account the possibility of others being careless.
Yes.
If I go further, paragraph 8. Paragraph 8. The tribunal has noticed that the deceased was driving vehicle at a high speed with a view to attend the marriage function. Manner of accident as deposed by the claimant's witnesses indicate that deceased was partially responsible for the accident. High Court was wrong in holding that deceased had not contributed to the accident, and there was no contributing negligence. Taking into account the evidence of the witnesses, it can be certainly said that there was contributing negligence. Proportion can be fixed at 1:4 from the compensation as awarded. A sum of rupees 1 lakh with round figures needs to be deducted. Therefore, the compensation is fixed at rupees 4 lakhs.
Yes.
The last paragraph. The two before last, paragraph 11. Again, it's just fortifying this. Paragraph 11, lordship is there. Therefore, when two vehicles are involved in an accident and one of the drivers claims compensation from the other driver alleging negligence, and the other driver denies negligence or claims that the injured claimant himself was negligent, then it becomes necessary to consider whether the injured claimant was negligent, and if so, whether he was solely or partly responsible for the accident and the extent of his responsibility, that is his contributory negligence. Therefore, where the injured is himself partly liable, the principle of composite negligence will not apply. Nor can there be an automatic inference that the negligence was 50-50, as has been assumed in this case. The tribunal ought to have examined the extent of contributing negligence of the appellant and thereby avoided confusion between composite negligence and contributing negligence. High Court has failed to correct the sentence. As I stated earlier, this is not a case of composite negligence.
Yes.
In case of composite negligence, two or more vehicles collide, and I, being an outsider, a third party, I suffer injury or I die. I do not contribute to the accident. So it is a case of composite negligence. Your Lordship has seen that Kheney, judgment 3 judges in Kheney says, when the fault is not mine, and it is very difficult for me to assess, which of the 2 or 3 is more responsible, liberty has been given to me to proceed against any one of the 2 or the 3 or the 4. I will take my money because of my death or my injury. And as far as the proportion is concerned, what is to be given by whom, that inter se that they will decide in a separate forum, either in the civil court or before that particular court, that you 3 or you 2 decide among yourselves that who was more responsible, who was less responsible. I suffered injury as an outsider, so let me get my money, and then thereafter you proportion among yourselves before the court of law. This is not that case. This is not a case of composite negligence. The Lordship will kindly pardon me for troubling the Lordship with this definition of composite and contributory negligence. So, contributory negligence is the specific case of mine. Honorable Supreme Court, Meera Samanta, I have met. I have also met the Supreme Court's this particular issue, that yes, before deciding the quantum of compensation, what is to be given to the claimant, either to the injured victim or to the heirs of the deceased, if the issue of contributory negligence is involved, then my lord, the proportion or my lord, the percentage of contributing negligence has to be decided first. From the total compensation, you delete that amount, whether it is 80%, 100%, 10%, whatever that is, my lord. That onerous task has been given to the Hon'ble.
Yes.
And then you deduct that, and whatever is the balance, then pay out that compensation. Because one cannot take advantage of his own fault. I try to commit suicide. And then in 166 proceeding, my lord, I take advantage of my own wrongdoing. This is not permissible. My lord, every day, my lord, is coming, going, my lord, to the court, at least, my lord, forget about other places. Your lordship sees, my lord, how the vehicles are treated. Whether in all cases, my lord's driver is responsible. I put this question, my lord, to myself, and I don't, because, my lord, we all travel. Most of us travel in car. My lord, can it be said, my lord, the way the bike riders ride, the way the minibuses ride, the way, my lord, these taxi cabs ride, my lord, in all cases, my lord, if an accident takes place, whether my driver would be responsible, whether I myself, if I am driving, whether I shall be responsible.
Yes.
My lord, these things have to be, my lord, considered, my lord, while deciding an issue. Just because, my lord, somebody for his own fault, my lord, commits an accident, for that, my lord, and then, my lord, it's not only my lord, an accident being committed, my lord, it boils down to money. You commit an accident, you suffer injuries, okay, no. Now you say you give me 20 lakhs, 30 lakhs, 40 lakhs. Not there the difficulty arises. Had it been an accident, had driver been punished, had that, my lord, he has gone to the jail, or, my lord, had he suffered, my lord, I wouldn't have mind. Now you come to the court and you say that no, the entire fault was his, so you give me money. This is, my lord, where it pinches. This is why, my lord, I was showing that judgment of Suffolk. Every time you cannot blame, my lord, other person. My driver, my lord, hits a motorcyclist. Your lordship knows, my lord, kindly pardon me for repeating this. Every single day, my lord, I keep on shouting, my lord, slow, slow, slow. Even if I am driving, my lord, I cannot increase more than 30 kilometers per hour. Because of this fear that now I'm hitting, now I'm hitting, now I'm hitting. Every time, my lord, the fault cannot be mine. Or even
Yes.
for that matter, my lord, my landlord friend also drives a car. If he meets with an accident, I cannot say every time he's at fault. My lord, I'm sorry, my lord, for deviating, my lord, from this.
No, no.
My lord, hey, why not? My lord, on the issue of this contributing negligence, my lord, how Supreme Court in various cases has decided. My lord, I'll trouble your lordship, my lord, with 2-3 more judgments on the point of no, yeah, 2003 Supreme Court 4182.
Yes.
Lord, may I just Lord, in this case, Lord, in this case, the victim, I'm sorry. In this case, the victim was going on a bicycle. He collided, or the allegation was he was hit by a truck. Supreme Court said that no, that bicyclist, he was 50% responsible, for this accident, and the deduction, from the total compensation was made in accordance with that. Lordship will kindly say, will kindly just have a name, this the forum, and then the councils. Lordship will kindly see. Attorney General, he was there. Lord has seen that. The name of the council.
Yes.
Because, why I just indicate that, how, this point was taken, what argument would have been made, and how, Supreme Court was coming to a finding that no, every time, an accident takes place, it doesn't mean that the person, the heavier vehicle, or for that matter, the bus, here was a bus and a bicyclist. But bicyclist was made responsible, to the extent of 50%. I'll just deal with that, but will kindly, come. Paragraph 3. The fact starts from paragraph 2. Milord, paragraph 2 says, Milord, the last 3 lines, 4,01,000 was awarded.
Yes.
Milord, now, Milord, in Supreme Court, paragraph 3, in support of the appeal, learned Attorney General appearing for the corporation submitted that the High Court's judgment is vulnerable on more than one counts. Firstly, it is submitted that the parents being the claimants, the multiplier, no, this is multiplier. This is not the issue. The multiplier as adopted is not proper. Secondly, this was a case where the accident occurred more on account of deceased's negligence than that of the driver of the offending vehicle. There is a clear case of contributory negligence. That being so, the awarded amount cannot be maintained. Milord, then, in the response, the counsel for the claimant submitted that the award is just fair and needs no interference. Para 5, a plea which was stressed strenuously related to alleged contributory negligence, though there is no statutory definition. In common parlance, negligence is categorized as either composite or contributory. It is first necessary to find out what is a negligence act. Milord, I showed the name of the council, Milord, because this elaboration, Milord, perhaps only that gentleman could have done.
Yes.
Is the negligent act. Negligence is omission of duty caused either by an omission to do something which is reasonable, which a reasonable man guided upon those considerations who ordinarily by reason of conduct of human affairs would do or obligated to, or by doing something which a prudent or reasonable man would not do. Negligence does not always mean absolute carelessness, but want of such a degree of care as is required in particular circumstances. Negligence is failure to observe for the protection of the interests of another person the degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. The idea of the negligence and duty are strictly correlated. Negligence means either subjectively a careless state of mind or objectively careless conduct. Negligence is not an absolute term, but is a relative term. It is rather a comparative term. No absolute standard can be fixed and no mathematically exact formula can be laid down by which negligence or lack of it can be infallibly measured in given case. What constitutes negligence varies under different conditions, and in determining whether negligence exists in a particular case, or whether a mere act or course of conduct amounts to negligence, all the attending and surrounding facts and circumstances have to be taken into account. It is absence of care according to circumstances. To determine whether an act would be or would not be negligent, it is relevant to determine if any reasonable man would foresee that the act would cause damage or not. Your Lordship will kindly, my Lord, in the context of the evidence given, my Lord, your Lordship will kindly, my Lord, relate this. What is negligent? What a prudent man would have done. My Lord, while riding a motorcycle, you take the right hand of your pocket and then, my Lord, you from your left hand, you drive the motorcycle. In that context, my Lord, I'm taking the trouble, my Lord, and my Lord, inviting your Lordship to go through. To determine whether an act would be or would not be negligent, it is relevant to determine if any reasonable man would foresee that the act would cause damage or not. The omission to do what the law obligates, or even the failure to do anything in a manner, mode, or method envisaged by law would equally and per se constitute negligence on the part of such person. If the answer is in affirmative, it is a negligent act. Where an accident is due to negligence of both parties, substantially there would be contributory negligence and both would be blamed in a case of contributory negligence. The crucial question on which liability depends would be whether either party could, by exercise of reasonable care, have avoided the consequence of others' negligence. Whichever party could have avoided the consequence of others' negligence would be liable for the accident.
Yes.
If a person's negligent act or omission was the proximate and immediate cause of death, the fact that the person suffering injury was himself negligent and also contributed to the accident or other circumstances by which the injury was caused would not afford a defense to the other. Contributory negligence is applicable solely to the conduct of a plaintiff. It means that there has been an act or omission on the part of the plaintiff which has materially contributed to the damage, the act or omission being of such a nature that it may properly be described as negligence Although negligence is not given its usual meaning. It is now well settled that in the case of contributory negligence, courts have power to apportion the loss between the parties as seems just and equitable. This is what I was inviting a lordship. Apportionment in that context means that damage are reduced to such an extent as the court thinks just and equitable, having regard to the claim shared in the responsibility for the damage. But in a case where there has been no contributory negligence on the part of the victim, the question of apportionment does not arise. Where a person is injured without any negligence on his part, but as a result of combined effect of negligence of two other persons, it's also not a case of contributory negligence in that sense. It's a case what has been styled by Pollock as injury by composite. So, this is it. And lastly, your lordship will kindly see with it. Keeping, the last paragraph. The learned counsel, has, continued with this definition, what amounts to contributing negligence, what is expected to be, any prudent man's behavior, and just because another vehicle was there and I suffered injury, it does not necessarily mean that the other vehicle was solely responsible for the accident. All has been dealt with. Various cases have been dealt with. Indian cases, foreign cases, and the finding of Honorable Supreme Court is at paragraph 11. Keeping in view the observations made by this court in various cases, several other factors need to be taken note of. Deceased was unmarried, contribution to the parents who had their separate earnings being employed in education have relevance, possibility of reduction in contribution once a person gets married is a reality. The compensation is relatable to the loss of contribution or the pecuniary benefits. The multiplier adopted by the tribunal and confirmed by the High Court is certainly on the higher side. Considering the age of the claimants, it can never exceed 10, even by most liberal standards. Working out on that basis amounts to rupees 3.6 lakhs as the monthly expected income fixed by the tribunal and confirmed by the High Court. Looking into the nature of contributing negligence of the deceased, after making an appropriate deduction which can reasonably be fixed at 25%. The compensation amount payable by the corporation can be fixed at rupees 3 lakhs, including the amount awarded by the tribunal and confirmed by the High Court for loss of expectation of life.
Yes.
So, after taking the facts into consideration, what High Court had decided and what tribunal was there, their lordships in Supreme Court, deducted, this figure 25% for contributing negligence. There are two other judgments, I will be taking a lordship with, wherein, 50% deduction has been made on account of contributing negligence of the deceased. This is a very small judgment, 2 pages. Name note for Supreme Court 1967. The deceased herein was riding a scooty, two-wheeler.
Yes.
As in our case. Again collided with a bus. Their lordships, Honorable Supreme Court, decided over by the bench. Honorable Justice Torun Chatterjee, Justice H.S. Bedi. They held that the victim, the scooty driver, was 50% responsible for the accident. The facts, are at paragraph 4 and 5. Paragraph 4, may I read? Apparent was riding a scooty. By that time, one bus, being number so and so, came from the same direction from behind in a very high speed, in rash and negligent manner, endangering the human life. Lordship will say the allegation, how it has been made. Endangering the human life, tried to turn towards left side and hit the scooty. The scooty trapped under the bus wheel and was fully damaged. Appellant lost her consciousness and sustained severe injuries over the head, right leg, pelvis bone, and other parts of the body. Finally, she was operated for her head injuries and also treated for number of fractures. She was discharged from the hospital for the injury and medical bills. Claim application was filed. Compensation was allowed. Award was passed 12,32,000. I'm not saying that. By tribunal. 4th line. Award was 12,32,000. Award was challenged in the aforesaid appeal in High Court on the ground that tribunal erred in fixing the entire fault on the driver of the bus for the accident. And secondly, the quantum of compensation was also on the higher side. cross objection filed by the claimant was for the increase in quantum. It's true that the tribunal came to a conclusion of fact that due to total negligence of the driver of the bus, accident took place. And Millard, and the calculation was made, sum of rupees 12 lakh odd was awarded. However, in appeal, High Court by the impugned order came to a conclusion of the fact that tribunal had lost sight of the fact that the spot Mahazar clearly indicated that the scooter driven by the appellant hit the rear wheel of the bus, indicating that the claimant was also negligent to a great extent. Next paragraph, 5. Looking to the finding of the tribunal, we also find that the tribunal also came to the conclusion of the fact that the respondent was also negligent and his responsibility was more. That is, when a scooter was going on the left side of the road, the driver of a heavy vehicle ought to have utilized the road, or when taking a turn towards east, he ought to have observed the light vehicles that were going on the left side and then take a turn and not suddenly come and take a turn. The scooter was on the left, the driver also took left. So the scooter hit that bus from behind and then it went under the bus. So it was also the responsibility of the scooty when the bus driver was turning left and you are behind the bus driver, you should be more reasonable, more cautious. The finding of the tribunal would indicate that the responsibility of the accident was more on the respondent and therefore it cannot be said that the appellant was also negligent. From the opposite finding of the tribunal as well as of the High Court, which was on consideration of fact, it would be clear that some contributing negligence should also be attributed to the appellant. Considering the entire material on record, High Court reversed the finding of tribunal and came to a conclusion of fact that compensation to the extent of 50% on the ground that the appellant was also responsible for the contributing negligence should be on the petitioner. This finding of fact arrived at by the High Court, reversing the finding of tribunal, could not be said to be perverse or arbitrary in nature. In this view of the matter, we are not inclined to interfere with the order of the High Court, reducing the compensation to the extent of 50%. But I'll not go to the last paragraph. So we got 50% because of the wrong driving on the part of the scooty driver.
Yes.
Deducted. I'm not the last minute on the point of contributing negligence, I'll show it to your lordship. This is Vijay Kumar Dugar versus Vijay Dutt, Hon'ble Supreme Court. AIR 2006, Supreme Court 1255. But in this case, the deceased
Yes.
2006. Deceased was driving a Maruti car. Like our the case, it collided head-on with a bus. Honorable Supreme Court, taking note of entire facts, held that no head-on collision, 50% contributing negligence has to be deducted. So, the deceased as a prudent man for the deceased to have taken due care and precaution to avoid head-on collision when he had already seen the bus from a long distance coming from the opposite direction. Your Lordship will kindly see what a prudent man would do. My Lord, I see from a long distance, my Lord, a bus coming in a very zigzag manner, and I'm driving a car, I'm moving towards that bus. If I consider myself to be a prudent man, what would I do? I would move in that direction that, okay, you come. No, my prudence would say something to me, my Lord, that you hold on. If I can see that bus, that is what the evidence of, my Lord, this bit of a tweet. From 100 meters, you could see that zigzag manner bus is coming.
Yes.
And this motorcyclist, the deceased motorcyclist in the instant case, my Lord, what we are doing, he could not see. From 100 meters away, this cyclist, this gentleman who was giving as an eyewitness, who was giving witness, he could see. And the motorcycle rider, my Lord, who was going in that direction, seeing that the truck is coming in a zigzag manner, he lost all his prudence, did not do anything. He went and collided straight with therein, putting his right hand in his pocket. My Lord, going further, when he had already seen the bus from a long distance coming from the opposite direction, it was head-on collision in which both the vehicles were damaged, and unfortunately, Rajkumar Dugar died on the spot. The MSCT, in our view, has rightly observed that it had been knocking on one side of the car. The negligence or rashness could have been wholly fastened or attributable to the driver of the bus, but when the vehicles had a head-on collision, the drivers of both the vehicles should be held responsible to have contributed equally to the accident. The finding on this issue is a finding of fact, and we do not find any cogent and convincing reason to disagree with the well-reasoned order of the MSCT on this point. The MSCT has awarded interest at the rate of 10%. This is 50%. I say, after going through these, there are hundreds of judgments on this case, on this issue, and I can trouble your Lordship with those. I will not give any more judgment. But if the need so arises, if your Lordship so call for, I can give hundreds. No issues about that. On the point of contributory negligence and how the reductions are being made all over the country, various high courts, including other Supreme Court judges. But I'm not troubling your Lordship with this. But this why I said, because the issue herein, what I say, in comparison to each of the cases what I have placed before your Lordship, wherein 50% deductions have been made by Honorable Supreme Court, I stand on a better footing. In my case, I pray for 100% contributory negligence of the deceased because the driver, the best witness in terms of the Supreme Court, in terms of our High Court, comes up before the witness box and he narrates the incident, which does not happen in any of these cases. Yes, I'm always at better footing in comparison to the cases what I've cited before your Lordship. Therefore, I pray for 100% contributory negligence in my case, because that was the sole reason. You cannot drive motorcycle with your left hand. This was on the point of contributory negligence. And as far as the quantum is concerned, I'm not troubling your Lordship. There is no cross objection in this appeal. If I lose, whatever money is there, it goes to the claimant. Only, this 1/4 deduction has already been made. As far as the tax part is concerned, I am supporting the judgment of the learned tribunal. Learned tribunal judge has deducted 20. There is no cross objection. Still, I go a step further. Learned tribunal judge has deducted 20% of the income. This is a case of 2010. The victim filed income tax return, chooses not to come up before the court with clean hands. Since it was not placed before the learned tribunal, 1 month salary slip would not do, or 2 months salary slip would not do, because learned tribunal judge deducted 20% as TDS. 2010, the deduction, we are not exactly aware of. And if deduction has been made, then you go and you take your refund from the income tax department. Why are you not coming with clean hands before the court? You ask for 30 lakhs. Yes. And you don't give documents. From where, the learned tribunal, I put this question to myself, will find the documents. So, for that reason, 20% deduction has been made, your Lordship will kindly, not that part. And as far as, since cross objection is not there, I am not dealing, with those facts with regard to enhancement at all. Yes. I am grateful to. And the other one,
তাহলে আমি করে দিই, আমি নিয়ে নেবো।
আরে না, আমার কাছে
But so far the judgments are concerned that we distinguish on any date. So far the fact is concerned that I can. আমি এখন xerox করে নিই।
আপনি নিয়ে
আমি
নেন।
xerox করে নিই।
যদি এখন দরকার আছে নিয়ে আমাকে ফেরত দিন।
না, না, আমি xerox করে নিয়ে নেবো।
ঠিক আছে, ঠিক আছে।
tomorrow,
Judgmentটা দেখে নিই। এতগুলো judgment
tomorrow you come on with the judgment and fact, everything. Otherwise,
but so far the
it
five
cannot be
judgments
like the piecemeal way.
five judgments has been relied by my letter and things.
An insurance company has a right to reply on that point.
Definitely.
Tomorrow, first night.
আমি judgment গুলো আমি আগে দেখবো না একটু দেখুন। আমার হাতে কি করে? আপনি খুব জানতে চান তোকে whether this is going to negligence or not.
Very well. Yes.
Tomorrow. Insert.
যা তোর ইচ্ছে তুই
Another
যা।
matter is
The argument heard in part. Let the matter fixed tomorrow. For further up.
first step. I think
First item, part of question.
Besides the lawsuit, they're asking me, Mr. General, for producing the case that in respect of aircraft listings. Lord, this matter is now goes to appeal. If so, the first Lord, I am see the security and the memo of evidence. Lord, I am only further saying the to this manner the two numbers of the in the FIR number is valor 1 and in the valor charge the number of the offending is or two eyewitness proof. Out of two eyewitness, one of the eyewitness is the charge sheet.
The papers. City.
But initially there was a confusion regarding the number of vehicles, commuting vehicles, but that has been cleared out, as you can see in paragraph 11 of the.
না না কি দিচ্ছ আমাকে না দিয়ে চর্চা বলেছে কি দিতে
আমার একটাই কপি আছে আমার
তাহলে ওটা দিতে কেন
তোর এত
You serve memo of the evidence both parties. Memo of the evidence.
ফটোকপি করে আমাদের দিয়ে দিও
না ফটোকপি দেখ না তুই আমার দরকার নেই
তো সব দেখে নি
আমি দেখিনি দেখ না
বলছিস মিথ্যে কথা কেন দেখিনি
না স্যার বলেছে
মানুষ দেখ
Yes,
Milord, what I find here, Milord, the copy, what Milord, how the state has given. Milord, your lordship, kindly recollect the case.
in the FIR, the number was different. And there
Lord, FIR
another number is there.
Lordship.
This is the
FIR
case.
says 82.
Yes,
Lord, I'll take the only last two digits, Lord, for the convenience of discussion. Lord, FIR says 82. Two eyewitnesses come,
yes,
PW2 and PW3. FIR says 82 and motorcycle. Now, when this eyewitness comes up, Lord, at page 13, he affirms, Milord, your lordship has taken, Milord, made a mark. Milord, in the cross examination, Hero Honda.
yes. Hero Honda brand
Lordship.
caused such accident.
So Hero Honda 82 number. FIR was next day given incident vehicle 82. It's also in the written complaint. Milord, then at page 12, Milord, I'm sorry, not the previous page. It was blue color motorcycle. Another eyewitness. Page 12, lordship, perhaps Milord has taken a mark of that.
Yes, it is a
So
blue
blue
color.
color motorcycle, Hero Honda motorcycle. These two eyewitnesses, your lordship will kindly see the name of the eyewitnesses. Names, Milord. One is Hemanto Sahu, PW2, and Vikas Roy, PW3.
Yes.
Milord, PW2 Hemanto, PW3 Vikas. Lordship will kindly say, Milord, the memo what has been given to your lordship. Page number 2 of that. Milord is with the memo, Milord, given by the learned advocate for the state. Lord, see the number, page number 2, serial number 2, Vikas Roy,
Because
and then number 7, Hemant Kumar Sahu. These two are the eyewitnesses. These two are charge sheeted witnesses. Now, these two come before the court. They give one evidence. They are charge sheeted witness. Police says no, it is incorrect. Incorrect on the basis of what? Lordship will come to page number 3. The statement under 164, the statement of Narayan Chandra Sahu, son of so and so, state that Hon'ble Kumar Sahu আমার ভাই যখন গাড়ি লোড করে আসছিল সাইকেলে তখন রাস্তার একটা মোটরসাইকেল ধাক্কা মারে যার ফলে গাড়ি নম্বর 82 যা আমার লোকের মুখে শোনা কিন্তু আরো প্রত্যক্ষদর্শী যারা তারা বলছে গাড়ি নম্বর 714 আগে নম্বরটি ভুল he is not in the witness box. Those two who said 82 they are in the witness box. They give wrong number, they give wrong color, they give wrong make. I'm sorry, Milord. No cross examination to them. I mean, my lord, no affirmation from them that আগের নম্বরটা ভুল, পরের নম্বরটা কি, রংটা ভুল. They are charge sheeted witness. Their statement is to be believed, and if it is to be believed, then absolute contradiction. That is why I say, my lord, on the basis of Kalpana Ruidas, the judgment is deferred, my lordship. On the basis of Honorable Vyas Kotanaik's judgment, my lord, the Shivdas Machi. And on the basis of Supreme Court's judgment, my lord, Anil. Wherein this, my lord, contradiction of evidence was taken note of by the honorable courts. And then court said that no, this vehicle was not involved in the accident. Absolutely on the same point. Even this, my lord, the memo of the state government fortifies that. Because the persons who came before the court, his statement is not recorded. Some third person's statement is recorded at page number 3. And he is not coming to the court.
Who is the PW1?
PW1 means the widow,
Widow, okay. Defect complainant did not appear.
lordship. PW2 eyewitness, Hemanto, PW3 eyewitness, because absolute contradiction. They say another number, another vehicle is seized. They say another color, another vehicle is seized. They say another make, another vehicle is seized. Seized on the basis of what? On the basis of one X. And that X does not come up before the court. And these two are charge sheeted witnesses.
Yes.
That is the reason that I say this vehicle has been implanted. My lord, as an insurance company, my lord, what more can my client do? They say Bajaj, my lord, they say Hero Honda, red color. Both these witnesses. Page 39, your lordship sees Caesar list.
Yes, here is it.
Bajaj M80, number 114. Nothing is matching, Miller. And this nothing is matching on the basis of the statement of one individual who is not coming to the court. And two charge sheeted witnesses are appearing before the court who are mentioned in this memo of the state. They are giving a different number. Different color, different make. Miller, this is not a fit case, not for dismissal.
Yes, Mr. Bonik. Yes.
I'm obliged.
My submission before your lordship that that the only disputes whether as raised by my learned in the insurance appeal is that the number of the offending vehicle as mentioned in the FIR differs the mother, the number of the victim in the charge. In my case, my client has produced 7 exhibited documents.
Yes.
And 3 the oral evidence. But PW1 is the the widow. Widow has not seen me, actually. But PW2 and PW3 is PW2 is Vikas Rai, who, my lord, who was interrogated by the IO, and he was also charged with witnesses. He has come and say that the offending vehicle is WB 34C 7214.
Yes.
My lord, in everywhere in the claim application, the correct number is given. My lord, the statement of widow and the two witnesses my lord, they are all have given the correct number of the offending.
Yes.
But since it appears, my lord, the number of the offending vehicle is, my lord, WB 4582. Shows, my lord, my learned friend's contention is that there is a, my lord, implantation of the vehicles. My lord, your lordships, my lord, last week, my lord, on the same, my lord, incidents, my lord, where the, my lord, charge sheet has not been, my lord, filed, where the delay in lodging FIR. While my learned friends and Mr. Jointu Banerjee, my lord, argued, and after hearing the, my lord, argument, your lordship was pleased to call for the CD. And CD was produced, and it appears from the CD that due to rash and negligent driving of the driver of the offending vehicle, the accident was caused. My lord, I have gone through the memo. Here, my lord, there was a, my lord, the status, the information, even in 164 statement of the FIR maker is there. My lord, the FIR maker is the brother of the, my lord, the deceased, who lodged, my lord, the FIR at about 11:30. My lord, accident took place at night, 9 p.m. My lord, in a place where there is no, my lord, thinking by our assumption that there is a no, my lord, my lord, lightened, my lord, the situations. In the, my lord, darkened, my lord, the situation, he has given that the, my lord, that vehicle, my lord, was by brothers, my lord, the accident. But after that, my lord, before the learned magistrate, he stated that what I am mentioned, my lord, in the FIR, that is the correct number is not there. Correct number is WB 34C so and so. And after taking, my lord, evidence, my lord, the learned magistrate, my lord, as per, my lord, CD, possibly it is there that the learned, my lord, ACGM or CGM directing the investigating officer to trace out the what is the which vehicle, my lord, caused the accident. And the investigating officers, after, my lord, investigating so many persons, my lord, came to conclusion that vehicle is, my lord, 4582 is not the offending vehicle. Offending vehicle is, my lord, is 34
C721.
34C 7214. And, my lord, on that basis, my lord, charge sheet was, and also, my lord, in the charge sheet, my lord, which was mentioned, so far as, my lord, I have gone to the, my lord, the memo as, my lord, handed over my lordship, that it is a, my lord, due to rash and negligent driving of the driver of that offending vehicle 34C. My lord, the victim is died on the spot. And he was charged sheeted, and case is pending subjects. My lord, here the insurance company, my lord, has drawn your lordship attention that there is a, my lord, some difference. My lord, what difference? Difference is color. Is a, my lord, black color or yellow color or something. My lord, kindly appreciate, my lord, at night, my lord. What the, my lord, the brother, my lord, of the deceased,
Then how at night, when the vehicle was not stopped, how the other person stated the number?
Other person,
Other persons means the,
no, my lord,
except the defecto.
my lord, after the victim injured and succumbed to injuries, my lord, the brother also, my lord, accompanied with his brother going to the local police station, area police station.
Lost the FIR.
Lodge a written complaint at 11:30. And the case was started, my lord, after the days at 2:20 or 2:30. It's clear.
Yes.
It is not a case of delay in lodging FIR.
This
It is not a case of implantation of the vehicle. My lord, it is a case where, my lord, the brother, my lord, who saw that the vehicle dashed, my lord, my brother and fled away, and my lord, the offending vehicle is so and so and so and so.
Yes.
But my lord, he came. When the case was started, the investigating officers, my lord, sought to find out the vehicles. My lord, he prayed before the learned magistrate. That vehicle was not, my lord, traceable, or that vehicle was not there. But I have collected some information from the other pupils that vehicle, my lord, had caused the accident, and for accident, my lord, this is victim that. My lord, learned magistrate accepted 164 statements, and also after investigating the matter, the charge sheet was filed. Charge sheet was accepted by the learned magistrate. My lord, in this case, the insurance company, my lord, has not done anything. They have, my lord, the insurance company has neither produced any, my lord, the oral evidence, nor produced any documentary evidence to rebut my case. My lord, here the, my lord, eyewitness is not, my lord, one eyewitness. There are, my lord, two eyewitnesses who, my lord, say the correct number of the offending vehicle, and there is no, my lord, anything, my lord, comes out that, my lord, the learned tribunal misbelieve my lord, the statement of the, my lord, two eyewitnesses, and that's why the tribunal came to conclusion that offending vehicle has caused, due to rash and negligent driving of the driver of the offending vehicle, the accident was happened, and award was, my lord, given. Without, my lord, any weapon, my lord, dhal nei, tarwal nei, nidam shatta, and come that says in the appeal court that this is the, my lord, the case. It is a case of implantation. It is a case of fraud. My learned friend realized, my lord, in earlier occasions, the, my lord, the Hon'ble also realized the, my lord, the decision of my lord Rafi. Also realized the decision of, my lord, the order passed by the Honorable Justice Vivas Patnaik. My learned friend also realized, my lord, in Jayanto Banerjee's case, that the, my lord, the order passed in Kalpana with us. Your lordship
Cases
has
are
gone through.
different in separate perspectives.
Yes, my lord, that case is delay in lodging FIR, and charge sheet was not filed. But
In
after
this case, the prompt FIR is there with the number.
yes,
That's your loss.
That goes against you.
I'm grateful.
yes, my lord, I argued, my lord, my lord, the last occasion,
Yes.
the FIR, the contents of FIR is not a substantive conclusive evidence. And on the basis of the, my lord, the decision of the, my lord, in Virat, learned tribunals also hold that the, in accident, my lord, FIR is often lodged in a hasty way. The decision was rendered by the, my lord, the High Court of, my lord,
FIR is not the substantive piece of evidence.
the
It has
substantive
corroborative value.
corroborative evidence.
Yes, I know.
And charge sheet, my lord, also, my lord, is
Also, FIR is
corroborative
the evidence. Nothing is.
Said. But, my lord, what are the, my lord, the evidence? Malad, which can prove, which can establish my case, is the Malad the evidence, Malad, which has unrebuttable, which was uncontroverted, which was not Malad has no contrary evidence. The two eyewitnesses, Malad says the correct number. Even if Malad in the claim application, the correct number is given. In the written statement, they have not taken any point that vehicle is so and so and that vehicle is implanted. Even if they have not challenged the charge sheet, they have not challenged the seizure list before the tribunal. Now, on relying on Mita Samanto and also the other judgments, last occasion I produced the involvement of the vehicles, where the dispute arises. I submitted the Mita Samanto's case that was rendered by the division bench of this honorable court, decided over by instructing the honorable Justice Pascal Bhattacharya. Also, that Mita Samanto was followed by the another division bench, where the honorable Justice Dipankar Datta, as his lordship is followed. In Pratibha Pani's case, in Sujata Banda's case. And also one case, Bajaj Alliance Insurance Company versus Anjali Mondol. Also, followed the Mita Samanto. What is the propositions, laid down in the Mita Samanto? That where the insurance company has raised the point, the involvement of the vehicles, the insurance company has to discharge some duties. What are the duties? They have after taking leave under section 170 of the Motor Vehicle Act. Your lordship is aware, when tribunals granted permissions by allowing the 170 petition to take defense on all points, even if not the points confined 149.2, they can take others the points. If they have not produced the driver, the owner of the offending vehicle, who are the best persons to narrate the happening of the accidents, the adverse inference may be drawn that on the date that offending vehicle was involved. It is the proposition laid down, in Mita Samanto's case. And Mita Samanto's case, also confirmed in Bajaj Alliance Insurance Company versus Anjali Mondol. Also, Mita Samanto case has been followed in a the Lakshmi Bhai versus Karnataka State Corporation. Also, earlier of the Supreme Court also relied the Mita Samanto's case. And also, latest judgments, is Pratibha Barik. On that day, I have not placed. Here also the division bench presided over Dipankar Datta, reported in 2018 ACJ. Here, the case is that the vehicle is Podini premium in the FIR. But eyewitness says that it was a Fiat. The insurance company has doubted why the FIR says Podini premium and eyewitnesses says the Fiat. That the division bench, relying the Mita Samanto's case, says that Podini premium Fiat are the same vehicles. And relying on Mita Samanto's Pratibha Barik National Insurance Company, it was appealed by my learned friends. Where the appeal was dismissed. Your lordship kindly have a look the National Insurance Company versus Pratibha Barik. Didi ekটু জজ সাহেবকে দেবেন? And your lordship kindly, my lord, the decision which I have cited, my lord, in earlier occasion, the Bajaj Alliance versus, my lord, the Anjali Mondal, where the father has, my lord, says the vehicle number is, my lord, as a, my lord, wrong number. Same, my lord, police stations, my lord. But the, my lord, তুই হাসছিস কেন? নাটক তো শিখেছি যে, আমাকে একটু বাংলা করে তোর বাংলা করার সময় আমি তো হাসি না। My lord, your lordship kindly have a see, my lord, the Bajaj Alliance Insurance Company versus Anjali Mondal. Also, my lord, it relates to Agra PS. My case is also Agra PS.
What does it?
No, my lord, but what my learned friend is laughing, my lord, I say that on thinking that Agra PS and this case, that is easy. My lord, he has laughed. My lord, your lordship kindly consider the Bajaj Alliance versus Anjali Mondal, where the fathers, my lord, says the wrong number of the OPD bill, which caused the, my lord, the
Yes.
where also the, my lord, the Bajaj Alliance versus Anjali Mondal relies on Mita Samanto. Protima Barik also relies Mita Samanto. My lord, I am also relying the Mita Samanto. And I also, my lord, rely the, my lord, the judgment of, my lord, relating to, my lord, the FIR and the, my lord, the, what is the FIR? What the value of, my lord, the contents of FIR? My lord, different Honorable High Court says that FIR is made in a hasty way. It cannot be substantive or, my lord, be, my lord. It may be my corroborative evidence. But the evidence which can establish or prove my case is the two eyewitnesses and the charge sheet. My lord, your lordship, very recent decision in Asha Law's case. My lord, your lordship, very recently the Supreme Court decided on 1st May 2023, just 2 months ago, where in the FIR, my lord, there is no number of the, my lord, offing the vehicle. But in the charge sheet, my lord, there is a number of the offing the vehicles. And also, my lord, this number was established, proved before the tribunal by the eyewitnesses. But the, my lord, tribunal awarded against that appeal was preferred. High Court believed the, my lord, the evidence of the eyewitnesses and, my lord, relying on the, my lord, the contents of FIR. Matter went to the Supreme Court. Supreme Court says, but the Supreme Court says, kindly have a look. My lord, may I read, my lord, paragraph 4.
Yes.
Having heard the learned counsel for the appellants and also the learned counsel for the respondents, we have at the outset averted to the consideration made by the MACT. Insofar as the involvement of the vehicle and also the rash and ignorant driving of the driver of the vehicle, the issue was considered while answering issue number 1, which has been raised for consideration in that regard. With regard to involvement of the vehicle, the claimants, apart from tendering their evidence, had also examined PW3, the investigating officer who filed the charge sheet. This is for the reason that initially the details of the vehicle was not mentioned in the FIR, and it was during the course of investigation the vehicle had been identified and charge sheeted had been filed. The MACT, having taken note of this aspect and also having taken into consideration that the respondent number 3, who was the driver of the vehicle in question, though was notified, had not appeared. That is the proposition, my lord, as laid down in Mita Samanto.
Yes.
Had not appeared. Further, the insurance company also did not take any steps to secure and examine the said driver with regard to the accident, since the evidence could have clinched the issue. Therefore, taking all these aspects into consideration and in the matter where the claimants had discharged their initial burden, the MSCT had held the accident to have occurred due to negligence of the driver and the victim in question to be involved. The High Court, however, without considering this aspect of this matter, had already discarded the evidence of PW3 since he was not the person who had conducted the investigation, though he had filed the charge sheet. Such consideration by the High Court is not justified in the facts or circumstances since the investigation and filing the charge sheet is a continuing process. So, my lord, this case is smaller on the back of my case. Here are the tribunals, my lord, considering the, my lord, the charge sheet and that is, my lord, the report of the investigation, and also relying on the, my lord, the eyewitnesses came to conclusion that victim, my lord, caused the accident. Only, my lord, in a, my lord, number mentioning FIR. FIR is not a, my lord, corroborating substantive evidence.
I understand.
Now, my lord, one thing, my lord. Your lordship, my lord. এটা একটু দেবেন। এটা একটা সুপ্রিম কোর্টের জাজবে না রিপ্লাইতে দিচ্ছি না, এটা হচ্ছে আমার পয়েন্ট, এটাতে এটা রিপ্লাই আমি তো রিপ্লাই দিচ্ছি না, আমি সাপোর্ট অফ মাই কন্টেক্সট দিচ্ছি। My lord, this is a case where the Supreme Court, my lord, decided on 17 April 2022. What is, my lord, the view expressed by your lordship in, my lord, earlier occasions? Even if, my lord, in absence of cross appeal and cross objections, my lord, since appeal is a continuation of the proceedings, so appeal court has a power to grant the just compensation in view of the benevolent aspects of the social welfare legislation like motor accidents. My lord, here the Supreme Court has considered that even if, my lord, the claimants have not filed any cross appeal or cross objections, my lord, the court, my lord, can award the just compensation. This is the view expressed by.
This is
Now,
not
my
a question here. This is not the issue here.
Because if your lordship, my lord, sees my assessment of compensation, my lord, I pay before I give to your lordship whether it can be considered or not. My lord, I have, my lord, paid my lord, the assessment where I pay that since the claimants are, my lord, 5 in nature, so 1/4 deductions is required because it is a case of 166. And also the future prospects of that victim. Victim was, my lord, 50 years. So, my lord, the future prospect of 25%, my lord, also we consider, and the general damage, my lord, 9,500, only granted 7,500, that is to be considered as 70,000. Now, my lord, this is a, my lord, the assessment, your lordship kindly have a look. It can consider consideration, my lord, that I give it to your lordship. But so far as my lord, the Supreme Court's, my lord, following the Supreme Court, my lord, dictum.
That's all.
Yes, that's.
Please take down.
On the issue, principally, principally, this appeal was on the point that the vehicle was not involved.
Only this point.
Only on this point. But my understanding, in counter argument comes up with the submission that in my appeal, he if my lord is not with me, if after all, at the end, if it is found, the composition amount may be enhanced. Your lordship, I oppose that. It should not be enhanced, the document what has been submitted to the court, that should be discarded. Because in my appeal, he cannot simply come up and say that no, the composition was granted without filing a cause objection or without filing a separate appeal. But it cannot be done. But this issue has been dealt with extensively by Honorable Justice Vivash Patnaik, taking note of all Supreme Court cases and of the cases of Honorable High Court, wherein it has been held that if a person, in motor accident cases, if a person comes up to the court with any specific plea, then while deciding that point, court cannot burden him with more. For example, my learned friend comes up with an award of ₹100. He comes up and says that no, I am not satisfied with ₹100. It should be ₹150. I appear and oppose that appeal. Your lordship will not bring him down to ₹75 under any circumstances.
Yes.
It cannot be. It would be preposterous. In the same manner, when I come up with your lordship, asking that the vehicle was not involved and the award was whatever, let's say ₹100. In my appeal, while deciding the issue whether the vehicle was involved or not, your lordship will not put me in further difficulty by enhancing that ₹100 to ₹150. Unless, I repeat, your lordship kindly pardon me, my learned friend comes up with a cross objection or with a separate appeal. In my appeal, he cannot pray for more. In the same manner, in his appeal, I cannot ask for less. This would be, this would be disastrous. This is the wording which has been used for this. The lordship will kindly not take any note of this document. And a lot of the statements were made from the bar. FIR is not substantive. Fine, FIR goes. Charge sheet is not substantive. Charge sheet goes. Then what remains? Eyewitness. That is exactly what my point is. Eyewitness remains, and we have this statement, which are at variance. The evidence of eyewitness need not be accepted. In an absolute fraudulent case, which your lordship will kindly take note of that and dismiss. And allow the appeal. I'm obliged, your lordship.
Who is appearing on behalf of the state? Names. Right. Instant appeal has been preferred by the insurance company against the judgment passed by the learned MSc Tribunal, first court contact on 14th July 2005 in MSCC number 165 of 2004, stroke MSCC number 156 of 2003. The brief fact of the case is that the predecessor of the claimant died in a road traffic accident on 1st of February 2003. Thus, the claim case was preferred before the learned tribunal. The learned tribunal, after receiving the written statement from the insurance company and after having the oral evidences on behalf of the claimants, passed the input order, input judgment, directing the insurance company to pay the compensation to the claimant amounting to rupees 3,21,500.
Will pass it.
The award was directed to be paid within 3 months, following which the 12% interest shall incur. Stop. The insurance company has preferred this appeal on the sole ground that the offending vehicle hearing number WB 34C 7214/7214 is not at all involved in the alleged accident. Stop. It is the submission of the insurance company that the vehicle hearing number WB 32 stroke 45822 was involved in the said accident, but the reasons known to the claimants the FIR was made in respect of the involvement of the said vehicle bearing number WB 32 stroke 4582, but reasons based known to the claimants. They have filed the claim application in respect of the new vehicle bearing number 34C 7214. Learned advocate for the insurance company argued hard on the point that nowadays there are several instances that several vehicles are running in the street without such policy, and in all motor accident claim cases, several vehicles were implanted. The view was observed by the Honorable Apex Court in the judgment of the judgment of Safiq Ahmed versus ICC Lombard General Insurance Company Limited, and the Honorable Supreme Court is also of the view in the judgment of Anil and others versus New India Insurance Company Limited that though there are eyewitnesses to the case of the claimant, but it appears that the case is a false case. Learned advocate for the claimant respondent submitted before his court that the claim application was filed on the basis of the number of the offending vehicle number WB 34C stroke 71. The claimant number 1, that is the wife of the deceased, appeared before the court stating the number of the vehicle to WB34C7. Stop. Two eyewitnesses who were cited as a charge sheet witness of the police case arising out of the same accident deposed before the tribunal, stating the number of the vehicle to be 34C714. Thus, there is no confusion in the case of the claimant regarding the involvement of the police. To understand, the insurance company has contested the claim case by filing it statement. So, the insurance company has also taken the lead under section 170 of India to contest the claim proceeding on all available grounds. But the insurance company has adduced no witness, whether oral or documentary, to prove their claims. Moreover, the fact of implantation of new vehicle was never raised. Of new vehicle was never raised. Stop on that score. He cited a decision of the division bench of this Hon'ble Court, passed in SAMANTA, wherein the division bench of this court is of a specific view that when the insurance company has not produced any evidence, though they have obtained the leave from the learned tribunal under section 170 of India, they are free before the appellate court regarding implantation of new feature cannot be entertained. He also cited the decision of Pratima Bari and Anjali Mandal. Pratima Bari, wherein the ratio of Mita Samantha was followed. Next slide. Learned advocate for the claimant also cited a decision of Anjali Mandal, wherein FIR was lodged on wrong vehicle number, but the investigation of the police was ended in charge sheet by citing the vehicle number, citing the correct vehicle number, and the claim application was filed. Claim application was filed on the basis of the involvement of such vehicle whose number was mentioned in the charge sheet. In that case, the claim application is very much maintainable. We also cited the decision of Honorable Apex Court passed in Asalota, Suryakanta, Pali, and others versus New Persons Company, wherein the FIR was lodged without any vehicle offending vehicle number, but after the investigation of the police, the number of the vehicle appears, and the Honorable Supreme Court is of view that there is no justification to disbelieve the investigation of the police regarding the involvement of the offending vehicle. You argue that in this case, stop the investigation. We argued that in this case, the accident happened in night. Stop. Thereafter, the FIR was lost in a hasty manner. Thus, the number of the vehicle was mentioned in the FIR erroneous. Vehicle was mentioned in the FIR erroneous. Further point was that after receiving the knowledge from the witnesses. The defect complainant appear before the learned magistrate, learned jurisdictional magistrate, and made a statement under section 164 CFS in respect of the correct offending. On that score, scientifically submitted that the point raised by the insurance company in this case is baseless. The appeal is liable. But the lauded advocates peruse the materials and the paper books. In the course of argument, it appears to me that the FIR of the case was registered with the AGRA PS on 1st February 2003 at about 23:55 hours. It was contended in the FIR that the accident took place by the offending vehicle number WB32 4582. The seizure list was also exhibited. Which stated that the article was seized, that is the motorcycle, was seized on 28th of February 2003, which is a Bajaj M80 motorcycle of red color. Stop. It further appears that the PW2 and PW3, who was cited as a charge sheet witness in the police paper, as a charge sheeted witness in the police paper, deposed before this court as before the learned tribunal as PW2 and PW3. Both of them had stated during their cross-examination that the offending vehicle was Hero Honda brand and of blue color. Considering the confusing statements, the specific order was made by this court to bring the scene. Stop. Learned advocate. Considering the confusing statements, city learned advocate appeared along with the city for the state appeared in this association, appeared with the memo of evidence and the CD of AGRA PS case number 10 of 2003. Peruse the CD. It appears that just after the accident has been happened, the police reached the spot by UD case number 7 of 2003 dated 1st of February 2003. By UD case number 7 of 2003 dated 1st of February 2003. The dead body was inquest. The inquest report was prepared on the spot. The inquest report stated that the accident was caused due to rash and negligent driving of a motorcycle bearing number WB 32458. After such inquest, the IO has collected the PM from the hospital, but no such progress of investigation is made in the city. Thereafter, suddenly, on 21st of February 2003, there are two witnesses along with the 161 statement of the de facto complainant, on the basis of which the IO made a submission before the learned jurisdictional magistrate to record a statement of the de facto complainant under section 164 CH. All the papers, that is the statement of available witnesses recorded under section 161 CRPC and the statement of de facto complainant recorded under section 164 CRPC contain the vehicle number to be WB 34C 7214. After such, the offending vehicle was seized by preparing proper seizure list, and the report from the MB department was received regarding the cause of accident, and the charge sheet has been submitted. Cause of accident and the charge sheet has been submitted. On perusing the entire CD, it appears to me that there are no investigation in this case regarding the involvement of the vehicle of the alleged accident, and also the whereabout the vehicle mentioned in the FIR in number WB 324582. The IO has submitted charges on the basis of the statement of available witnesses who deposed before this court as PW2 and PW3. The evidence of PW2 and PW3 is contradicted to that of the 161 statement as well as the statement deposed before this court. I make it clear that PW2 has stated before the police that PW3 appeared at the spot after 3 and 4 minutes of the accident. But in the police paper, they have stated that they were both riding the cycle altogether. Moreover, the identification of the vehicle by the eyewitnesses appears to be confusing story. The inquest report conducted by the police appears to be the independent one and believable. The inquest report specifically mentioned that the vehicle bearing number WB 32 4582 is involved in the alleged accident. Thus, at this juncture, I find there is merit in the submission of the learned advocate for the insurance company. on that score after perusing the police paper as well as the materials on record. Also the LCR and the CD. It appears to me that the case of the claimant is not at all visible and liable to be dismissed. Thus, the instant appeal has got valid, and the appeal order passed by the learned award passed by the learned tribunal is hereby set aside. Appeal is allowed. Connected grant applications, if any, are also disposed of. The appellant is at liberty to return back the amount deposited by them to the learned estate along with the credit. Along with the accrued interest depending on the contribution. Return the same.
But I just go to the case file. Yes, sir, can exactly case that.
Yeah, return the same.
Lord, may I just go through the case report, Lord, to check out what was the amount deposited, Lord, because it was changed briefly, Lord.
Yes.
I'm grateful to you. We are deep to your best.
Your memo of evidence should be there.
That should be kept in the record.
Yes. You only return the same.
We are grateful.
Yeah, sir.
You first call the part address. Yes.
Malad, this is Malad. I'm appearing for the respondent, Malad, of India in this matter. Mr. Jointo Banerjee had argued this matter, Malad, and taken time to argue this matter, Malad.
Where is Mr. Banerjee?
Malad, he's coming. I've spoken to him, Malad. May I, if your lordship kindly permits me, may I start, Malad? I've had a word with him. The case here is, Malad, the difficulty is this proposition is settled by the Honorable Division Bench of this court. That is staring at me, Malad. I will not waste your lordship's time. The case is that the person who's it has been stated that he fell down from the train while trying to spit vodka and he died, my lord. This is the fact of this case, my lord.
Yes.
Now this is squarely covered, my lord. He has relied on a judgment of Honorable Justice Dipankar Datta presiding over the division bench, my lord. And this has a similar facts, my lord. So I would not waste your lordship's time, my lord, arguing this because this point has been decided, my lord. I was humbly praying, my lord, your lordship will formally record my objection, my lord. That my prayer is that the order passed by the tribunal is right in every manner, my lord. Otherwise, my lord, I am having a difficulty because of this judgment of Honorable Justice Dipankar Datta. The facts are similar. The death was of a passenger who fell down from a train, who was also trying to do the same thing, and accident occurred to him.
Does the incident come within the purview of controversy?
Because I can't argue against this.
Yes,
And so, if I had the opportunity, I would have liked to argue, my lord, the point on this point, my lord, because of whether the negligence, my lord, of having known that this can result in death, my lord, but that point is not open to me now before your lordship now, because of the division bench order.
Yes, yes.
So, this is the matter of my lord Radha Yadav versus Union of India. This had also gone up to the Supreme Court. Judgment starts at page 14, my lord, of the paper book. May I place that one?
So, whether anyone deposed on behalf of the railway, one,
Yes.
station master.
On behalf of railway, my lord, there has been, my lord, the difficulty is, my lord, nobody has deposed, nobody has also challenged that he was not a bona fide passenger. Evidence is, my lord, that is the difficulty I'm facing.
Yes, yes. So, what was the award? 4 lakh.
No, here my claim was dismissed.
Okay, claim what is. That's right.
So already, my lord, I have already argued on the last day that if you lordship please to allow my claim, then it should be 8 lakhs, 4 lakhs, and interest
Up to 8 lakhs.
4 lakhs or 4 lakhs, and the interest should be calculated on 4 lakhs. If it is, my lord,
Lesser
below
than
than
8 lakhs.
8, then also 8, and it counts, my lord, more than 8, then also more than 8.
The highest capping is 8 lakhs. my
No, not capping. No, interest 8 lakhs এর উপর যেতে পারে, 4 lakhs এর উপর interest কম করে দেয়। হ্যাঁ, সেটাই দাবি থাকে।
No, one judgment is there.
Yes.
One my lord Radha Jadhav.
Radha
certificate
Jadhav judgment
and
by the
Dilip
Supreme Court.
Nandi.
Yes.
Radha Jadhav is like that.
Calculation. না না আপনার যেটা হ্যাঁ
And normally my lord, I have already seen 7.5% to 8% rate of interest given in railway.
I would, my humble submission would be, my lord, this used to be at the time when the rate of interest used to be high. Today, as on this day, my lord, the rate of interest by the banks, my lord, not more than 6%.
6-7.
Yes.
But that we are losing that interest. Rate of
No,
finding
in all cases, we are adopting 6%. We are adopting 6%. Uniformity will be there.
2003 is matter.
Whatever may be.
We are getting my lord simple interest, not much compound rate of interest. That is the problem.
Judgment is of today's date, my lord, because the tribunal has passed in our favor.
Very well.
We are not entitled to give them anything.
In view of my lord Dilip Nandi and Radha Jadhav, my lord, clarificatory judgments are there, man. After my lord Reena Jadhav, there are two judgments, one Radha Jadhav and thereafter Dilip Nandi. So they have already handed over that.
Union of India versus Dilip and others.
Yes, my lord. That
2021 TSC 1SC.
there, my lord, the rules has been my lord appended by the Honorable Apex Court. How the calculation
Compensation was given 7.5% per
7.5%. But because it is my lord 2003 is matter. We are getting my lord, we are getting my lord simple rate of interest, not compound rate of interest. And at that point of time, my lord, 15% was the bank rate of interest. We are not, my lord, I am not wanting my lord 15, 12, 9. My lord, your losses kindly grant 8% at least.
Whatever the bank rate of interest,
And
that
my
is a
lord,
reasonable
Supreme Court already observed, my lord. It will be, my lord, as the motor accident claim case grants. Motor accident claim case, there is no rules in the motor accident claim case, the rate of interest. Supreme Court in 3 judges bench, my lord, already observed how the rate of interest will be applicable. In my lord, the pendency of case, my lord, pendency, how long the case is pending, my lord, that should be looked at. This is one of the criteria. If it is not a very old case, then rate of interest should be more than normal rate 6, 7. It should be 9, 10, 11, 12%. It is, my lord, case of 2003. 20 years we are waiting, my lord. 8, no, latest of 5 weeks.
accident happened on 14/10/2003.
Yes, yes, that
This, my lord, and even, my lord, the judgment of the Supreme Court in Thaukai Purai and other, the rate of interest should be applicable not from date of filing, it is from the date of accident. Just like in workman's compensation or employee's compensation.
yes, that I'm not disputing. Only, my lord, your lordship, can you take up this matter, this judgment relied upon by my learned friend, my lord? Union of India was Reena Devi. Because of which judgment, my lord, I cannot even argue, my lord. This was a division bench judgment passed by the Honorable Justice Deepak Datta, presiding over the division bench, taken up to Supreme Court. Now, rate of interest, Honorable Supreme Court has categorically dealt with this matter, which is what I-
Reena.
Yes, my lord. Reena Devi, paragraph 30, my lord. এগুলো কত দিয়েছে? My lord, to avoid any confusion in the matter, my lord, the lordship will kindly take up this at paragraph 30.
6 করে দিলেও তো 120% হয়ে যাচ্ছে।
Paragraph 30, my lord. This is the second last page of this judgment, my lord. Rate of interest. But this has been specifically dealt with, my lord.
Yes.
My lord, rate of interest. As already observed, though this court in such and such held that the rate of interest has to be 6% from the date of application till the date of the award and 9% thereafter, 9% of the interest was awarded from the date of application in Mohammed. Rate of interest has to be reasonable rate on par with the accident claim cases. We are of the view that in the absence of any specific statutory provision, interest can be awarded from the date of accident itself when the liability of the railway arises up to the date of payment without any difference in stages. So, my lord, relying on that case, it was 6%, and from the date of, my lord, thereafter judgment, 9%, my lord. So, Honorable Supreme Court has approved this, my lord. Six percent is a reasonable amount. I know that is my submission. Doing one thing, madam, my formal
Yes,
submission is, madam.
Yes, yes, yes. The instant appeal has been preferred by the claimant appellant. Being acted by and dissatisfied with the judgment and order dated 30th January 2008, passed by the chairman of Railway Claim Tribunal, Kolkata, in connection with claim application being number U/784/2004. The big fact of the case is that one claim application was preferred by the appellant before the line commissioner on the ground that on 14/10/2003, the applicant's son, applicant's son, namely Indra Modo, after selling fish at Meyman Market, left for Meymari Market, left for Bardwan by a local train at about 10 a.m. to purchase ice stock. Ice or stock. During the office time, the train was overcrowded and he was standing at the door with the others. Stop. When the train was at Baka Bridge, in between Gangpur and Bardwan stations, he was about to spit by leaning his head from the door, and suddenly his door dashed with an electric post and he fell down from the train. Stop. The other passengers shouted loudly and tried to pull the chain off, but the ACP capital system was out of order and train was not stopped. The victim succumbed to his injuries on the spot. including FIR, I-card and monthly ticket of the victim, and other police papers. PW1, that is the mother of the, that is the present applicant, was deposed as deposed. Present applicant deposed before this court, before the commissioner as PW1, and one AW, not P. One Bimal Saha deposed as AW2 to be eyewitness of that case. Stop. Learned commissioner, after hearing the parties and after perusing the evidences on record, both oral and documentary, disbelieved the case of the claimant appellant and rejected the claimant case. Stop. Hence this appeal. Stop. Learned for the appellant submitted to this court that the deceased was traveling in that it was not disputed that the deceased was traveling at the local train at the relevant point of time with a valid ticket, valid monthly ticket. The monthly ticket was verified by the respondent and it was observed correct. He also pointed out that the dead body was identified and received by the grandfather of the deceased from the morgue after proper identification. Stop. The AW1, who was a co-passenger of the said local train, has deposed before the case, before the learned tribunal regarding the factum of the accident. But the learned tribunal has not believed the case of the claimant, on some flimsy grounds. We further argue that learned tribunal should have considered the claim case to be true and necessary award can be passed. We further pointed out that the observation of learned tribunal on the attending facts and circumstances of this case is totally erroneous. Stop. The police paper has already proved the death of the deceased due to falling from the train by virtue of PM report and other statement of witnesses. Thus, at this juncture, the case of the claimant cannot be disputed. We further point out that the observation of the learned tribunal regarding the disbelievability, regarding the not believability, regarding the observation of learned tribunal regarding the truthfulness of AW2 is not correct. Stop. It would appear from the evidence of AW2 that he was present at the same rail, same local train in same compartment. He knew the deceased co-passenger, though he was not aware the actual name and address of the deceased, but his statement cannot be disbelieved on the fact that at the time of at the just time of accident, he could not see the deceased who fell down from it. But it is the fact that after such accident, the AW2 returned back from the next railway station to the accident spot taken out the belongings of the deceased along with the I card and the ticket, monthly ticket, and deposit the same to the nearest station master. So, no evidence was adduced before the commissioner to contradict the statement of AW2. Thus, the statement of AW2 need be believed. Learned advocate for the Union of India submitted to this court that the learned commissioner has considered the evidences, both oral and documentary, and it is the observation of the learned commissioner that the claimants has failed to prove their burden to prove the case. He further pointed out that there is no illegality in the observation of the learned commissioner. He again pointed out that the evidences adduced by the claimant before the learned tribunal was properly scanned by the commissioner, and in result thereof, learned commissioner is of opinion that claimant has failed to prove the case. He again pointed out that the AW2 cannot be believed, as he stated before the tribunal that he knew the deceased prior to the accident. It is the reasonable suspicion before the learned commissioner that why the dead body of the deceased remain unidentified for long 3 days. On such substance, learned advocate appearing on behalf of the
One more pilot. This is self-inflicted. One more.
Submitted that the so-called accident is self-inflicted in nature. Thus, the Union of India is not liable to pay the penalties. Or the learned advocate peruse the materials on record. It appears that the accident stated to be happened when the deceased wanted to speed up by leaning his head from the train, from the running train. The same fact, whether this act of the deceased would be self-inflicted or not, which can only be considered, which can only be ascertained as per view of section 124A of Railways Act. Stop. Section 124A of Railways Act mentions some exceptions. Stop. The Honorable Supreme Court in Union of India versus Rina Devi has dealt with the same consequences, and Honorable Apex Court is of view that the act conducted, so-called act of spitting, leaning outside the train, is not come under the purview of self-inflicted injury mentioned in section 124 capital A with bracket B of Railways Act. Learned advocate for the appellant also cited some decisions reported in Union of India versus Radha Jadhav, Union of India versus Dilip and others. Yes, and Vandana Mishra, you have Vandana Mishra. Jamila, you have
Jamila also. Self-inflicted injury
yes.
discussed by the Supreme Court and Prabhakaran Vijay Kumar also. On that
And Union of India versus Prabhakaran Vijay Kumar and others. Stop. Peruse the observation of Honorable the Honorable Supreme Court with Prabhakaran Vijay Kumar and others has held that the injury inflicted by the passenger and the claim of the claimant under the Railways Act 1989 should be dealt with the principle of no fault damage. It has been also observed by the Honorable Appeals Court that accidental falling of passenger from the train carrying passenger is not come under the purview of self-inflicted injury. In considering the present facts and circumstances of this case, it appears that the learned commissioner has disbelieved the evidence of AW2 on the ground that AW2 has not seen the accident. It appears from the statement of AW2 that he is a co-passenger who usually travel with some other co-passengers regularly. Stop. By virtue of their travel in the same train and same compartment, they appears to be face known to each other. Their name and proper address may not be within the acquaintance of other passengers, but it is within their knowledge that where from the particular passenger boarded the train and where they left the train. Stop. It appears that AW2 has deposed before the Learned Commissioner that he knew the deceased on such way. The AW2 also stated before the Learned Tribunal that on the fateful day, the deceased boarded the train with the AW2 in the same compartment and beside the same door. Just because of the AW2 because of the fact that AW2 did not notice when when the deceased fell from the train, does not ipso facto prove that AW2 never witnessed the accident. Stop. AW2 was all along in the running train with the deceased, and he noticed that fell from the running train. Stop. It is the further evidence of AW2 that he returned back to the spot of accident from the nearest station and collected the documents from the possession of the deceased and produced the same before the station master. The statement of AW2 cannot be disbelieved on that score. Stop. Thus, the finding of the learned commissioner. The function and learned tribunal. Learned tribunal. On the value claims tribunal. On the tribunal judge. Functional only whether it workmates or implies compensation. I understand. So the tribunal in respect of AW2 appears to be erroneous. Considering the entire facts and circumstances, and considering the view of the Honorable Apex Court, the cases mentioned here in above, I am of the view that the claimant has successfully proved the case, and she is entitled to get the compensation as paid for. She is entitled to get the compensation as paid for. Thus, the appeal succeeds. Stop. The impugned order and judgment passed by the learned tribunal is set aside. Stop. To assess the just and proper compensation in this case, it appears that the claimant has filed the claim application claiming compensation amount to 4 lakh. Stop. By virtue of the notification of central government, yes, as notification published in the Gazette of India, Extraordinary Part 2, Section 3, Subsection 1, number 877, dated 22nd December 2016. The award, the sub-rule, the amount mentioned in sub-rule 2 is amended from rupees 4 lakh to rupees 8 lakh. Stop. In a case of death. Yes, sub-rule 2 is there for the The Honorable Apex Court in Reena Devi has discussed the amount of compensation.
Subsequently clarified in Radha Jadav's case, which is delivered by the Supreme Court of India.
Subsequently, it was clarified by the Honorable Apex Court
Para
in Radha Jadav
Para 10.
at Para 10. Stop. Considering the attending facts and circumstances of this case, the claimant are entitled to get the compensation rupees 4 lakh along with 6% interest per annum from the date of accident. Stop. If the amount, if the accrued interest along with the principal appears to be less than 8 lakh, then the compensation would be at least 8 lakh. And if the principal along with the accrued interest appears more than 8 lakh, then the higher amount should be awarded. Should be awarded. Stop. The Union of India respondent is directed to pay the compensation within 8 weeks.
12 weeks. 12 weeks, my lord. We'll try within that, my lord, because otherwise, my lord, it has consequences, my lord.
Very well. Let it be 12 weeks. You will file it before the commissioner or here?
Yes, my lord, before the registrar.
Registrar General High Court. Okay. My lord, one prayer, my lord. Only one appellant, my lord, before your lords. So, yeah, if there be a direction to issue the check in the name of Shikha Modak, the appellant, sole appellant carrying, then it will be better for us to receive the check
Through registration.
through registrar. We will disclose our identity and we will collect the check. Grateful, my lord.
The Union of India respondent directed to pay the compensation. Higher amount should be awarded. Within 12 weeks from the date of this order. Order through London Registrar General, Calcutta High Court. So by issuing an account pay checks in the name of the appellant. Shikha Modak. Appellant's data division. Srimati Shikha Modak. Assembly Shikha.
The bank, my lord, does only Shikha Modak. So, Srimati is
The appellant shall receive the check and upon proper identification and verification by the concerned office of the London State.
clear, my lord. That is the decision to give us the check before the petition.
Let them
But
submit.
they will deposit within a month, my lord, I know. Good office, they are possessing good office.
Stop. The instant claim case is pending since 2003. 2003. Considering the long pendency of the matter, the office of the London Registrar General is requested to disburse the check as early as possible.
Good.
If I may dispose to us. Also disposed to.
My lord, one thing, I pray for a short indulgence, my lord, not in respect of this matter. I was supposed to come in the morning to mention a matter, my lord. I could not, my lord, because I was stuck in another court. My lord, there are 7 other matters which are pending since long. I have taken steps in all matters, my lord. There were earlier directions by your lordship's predecessor, my lord, that let these matters appear in the monthly list, my lord. These matters are not appearing, my lord. Perhaps, my lord, the appellants are not interested, my lord. If it appears in the list, my lord, I can move forward. with
Very
these
well.
matters. May I hand over these
Yes,
matters?
yes. Call from the list. Item 3 and 4.
State level and I submitted that also referred to judgment. Tomorrow's appearing for the claimant.
Yes,
Due to non-supply of convention delay with regard to cross of friction, the matter is urgent.
very good. Okay, let it pass it over. I'm passing it over. Let's say appear. Seven I am applying. Who is appearing for the insurance company?
Mr. Isan Ganguly. You should file two applications, Your Lordship. One for appealment of the majority of appeal number 2, appeal number 3, and another application for expeditious disposal of the appeal. Now, very short point, Your Lordship, future prospect, general damage, and the multiplier. Now, Your Lordship, in the meantime, during the pendence of the appeal, Your Lordship, the appeal number 2 has been made. Now, if Your Lordship kindly permit me to correct the name, as she was Sumana now Pal.
To file an application.
Application for amendment. If you see, this is very minor correction, Your Lordship. Only the husband title could be Chaudhary, Sumana Chaudhary, me Pal, Your Lordship. Your Lordship kindly correct. Otherwise, Your Lordship, Soma Chaudhary.
Come with some documents at least.
Documents I got the certificate, I got a copy of the marriage certificate and the other card, Your Lordship, of the current other card. I've taken out the print, Your Lordship. Otherwise, Your Lordship, my client has to come from Jalpaiguri, Your Lordship. Attainment of the majority I filed, Your Lordship.
But where is the insurance company?
Your Lordship.
Where is the insurance company?
Mr. Ganguly, could I serve a notice on this afternoon, Mr. Ram?
Yes, come on tomorrow. Tomorrow possible?
Day after tomorrow, then, Your Lordship.
Day after tomorrow. Okay.
Today I will serve the notice.
Yes, you serve the notice and come on. Tomorrow. Any order
Lordship,
required?
Kindly, first one, kindly take it tomorrow, Your Lordship. Kindly tomorrow, I will serve the notice today in course of the day. So tomorrow I would try and mail after. Very short matter, Your Lordship.
Item number 7.
7.
Please take down. Learned advocate for the appellant required to serve notice upon the learned advocate for the insurance company respondent regarding the fixing of the matter tomorrow. Let the matter appear to the same person. Next.
Mr. Ashik Mondal is appearing for the claimant. Due to his personal difficulty, he has left the court. He requested me to prefer not to be paid.
Not today. Very well. Not today. Next.
Milord, item number 18.
Yes.
Milord, this is a appeal of claimant for the smaller insurance company. Milord, perhaps the Honorable Court report speaks that the file is not traceable. No key nahi, sir. Key nahi.
Names file.
Key nahi. What is missing? Milord, the entire file is perhaps missing. Your Lordship, Milord, on the last day it was paid before Your Lordship by my learned friend appellant, Milord, that Lordship will kindly give a direction for reconstruction. My Lord has also.
Order was passed, I think.
Lordship, yes.
Let me see. is the report that the case record was sent to the court number 3 on 24th of November 2017. Since then, it is not received by the department. This is the report.
So, since department is acknowledging, that they are not finding it, or would be kind enough, to direct the appellant to prepare or to reconstruct, the entire case file, on the basis of the certified copy of the documents, whatever was available with him, and then Lordship will fix up the matter anytime.
No, whether appellant is going to be directed or the department will be directed.
The department does not have the record. How will they, had the record been there, then the record would have been here before your Lordship.
No,
Record is
what-
not there,
What the reconstruction of record,
Lordship.
the rule is that the appellant or the petitioner or the plaintiff or the defendant or the parties of the case are directed to produce their documents and certified copies
Before the department.
before the department.
My-
Department prepared the document
Lordship.
and produced with the.
Application certificate copy has certificate. Your Lordship will kindly direct the appellant, my learned friend, for the claimant, to furnish all the certified copies of the documents before the department, and your Lordship will direct the department on the basis
Yes,
of the same, to reconstruct the records, Your Lordship will kindly, make it time specific, I'm grateful to your Lordship. ठीक है जी सर, अच्छा जी certified copy.
Okay, please take down. The application for reconstruction of the record of a thief was moved before this court, by virtue of which the concerned department was directed to furnish a report. The department has submitted the report dated 28th of June 2023. On perusing the report, it appears that the file in question is not with the department. Stop. The instant appeal is pending since 2014. For the speedy disposal of the matter, the Jan 3 of 2023-22 filed by the appellant for reconstruction of the record is allowed. Next part. The appellant is directed to furnish all the certified copies
There is one problem.
along with the memo.
There is one problem. My learned friend says, he had prepared these paper books. Paper book was given, before the Honorable Division Bench presided over by Honorable Justice Dipankar Datta. In the original, 2 paper books were given. All those are missing now.
Yes.
In the original paper book, he has given the original certified copy. And now he is having all the photocopies of certified copies in his custody. Original was placed before the court. It was there in the court record. Now that is missing. So he cannot produce another original one. And one more thing, I am not aware whether the lower court record has come or not. Or because if lower court record is also missing,
All are missing.
lower court record came and that also went missing.
Yes, went to the
Then I have to only rely upon photocopies and have to have absolute faith in whatever document he gives me.
I acted. No reply is given.
It's now. Stop. God.
stroke certificate copies, stroke the photocopies of the document pertains to the record of the instant appeal to the department, and on receiving such, the department shall prepare stroke reconstruct the record of the appeal. It appears that the report of the registered report of the concerned department as per the good. It appears the report of the concerned department then about the LCR. However, if the LCR is available, that can be placed with the reconstructed record. Stop. The appellant is directed to hand over the copies of the document to the department within a week.
Yes, sir.
Within a week, and on receiving the same, the department concerned shall reconstruct the record of the appeal within a fortnight thereafter.
Yes.
Let the matter appear in the list on 26th of July.
26 July. We are obliged to manage.
The proceeding was filed under section 163A. Now, claimants before the tribunal and before the honorable court is the wife and the mother of the deceased. Now, the deceased was a Khalashi. His income at that time was rupees 2,500 per month. The accident, your lordship, took place in the year in the year 2010, your lordship, September 2002. Now the employer came to the box. He deposed and certified that he used to give TTCs to 1,500 per month. When the London Tribunal, since the salary register was not produced, London Tribunal disbelieved. But a London Tribunal would happen without giving the notion that the London Tribunal assessed the income 1,500 per month. Whereas your lordship, it was claimed 2,500, and your lordship, the incident in 2010. The practice of this honorable court, your lordship, in 2010 is 3,000. Now, 2,500 is claimed. Your lordship, that could be allowed, your lordship. Second point, your lordship, this matter. As per the judgment, your lordship, I find that the multiply 11 was used. But your lordship, this is the application under section 163A. So multiplier according to the schedule, your lordship.
What is the age?
Age, your lordship, 40. So multiplier would be 60.
40.
40. Multiplier would be 16, your lordship. Your lordship, can you see above 35 but not exceeding 40 years? Schedule, your lordship. May I hand over?
No. Now, what is the multiplier adopted here?
Your lordship.
What is the multiplier adopted by the London Tribunal?
Your lordship, London Tribunal did not discuss that, but as per the quantum of the compensation, it comes 11, your lordship. If your lordship kindly come to the judgment.
Yes.
Good. Your lordship, kindly come to the judgment, your lordship. page 24 of my paper, inner page 5. Then a tribunal assess your lordship, the last portion of first paragraph, your lordship, as there is no sufficient evidence, the occupation and income of the deceased, the notional income 18,000 per annum can be taken into calculation of the compensation. So by applying structured formula, the compensation amount comes to 1,98,000. So 18,000 you'll see into 11 is 1,98,000. Thereafter, the landed table, thereafter wanted, that is correct, your lordship. So your lordship, multiplier would be 60. And the general damage, your lordship, in this case, nothing was given. Now, as per the section 163A, your lordship, 9,500 ought to have been given as general damage. So 3 points, your lordship. The income should be considered as 2,500 per month, and multiplier should be 16, and the general damage should be 9,500. These are 3 points. And the interest, so default interest was granted, so it should be mandated, your lordship. Can you see the last page of the judgment? Within 2 months, last 2 lines. Within 2 months from this date, in default and interest 9%. The 4 points, your lordship.
Apart from the age can be ascertained.
Your lordship, postmortem report, your lordship. Claim exhibit 5. I have annexed it. Page 44. You also kindly see name and address of the person in the postmortem. Line from top 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Your lordship can write date and time of examination. Then your lordship name and address and the age, your lordship. Age is 40 years at the last.
Any voter card or anything produced? No.
No, your lordship, no voter card, your lordship. Voter card of the mother and the wife, your lordship. Seven and 8. Only postmortem.
So one is income, second is multiplier,
Third is general damage.
general damage,
Fourth is
interest. Interest.
multiplier would be 16. General damage leads to your lordship 9,500. Since mother and wife. Deduction is correct, your lordship 1. Let's apply right.
What evidence you adduced regarding the income?
Your lordship kindly come to PW. PW1 first, your lordship the wife. Then your lordship the employer, PW3.
Page.
PW3, page 70. Soumitra Kaur. Family was there. Wife and mother. Something
Which was disbelieved by the tribe.
tribunal. So since the salary register was no. No, not. And another thing, I applies from the respect of chief that he has the issued any certificate. Which is he came to the box. He goes, no, but the certificate is not necessary.
What is the date of accident?
Your Lordship. Date of accident, Your Lordship, September 2010. It is Your Lordship, accident on 8th September 2010. Now, our High Court practice also up to 2010 3000. Now, here also 2005. And Your Lordship, kindly,
Yes. Okay, let me hear the appellant. Insurance company.
My lord, my contention is the income, whatever has been taken by the learned tribunal is absolutely correct. Because please come to,
Why 2,500 was disbelieved?
yes, please come to page 17 of the paper book.
Yes.
I, Sri Soumitra Karmakar and such, that is. Next is number 1 statement is that I am the owner of truck bearing number such and such. That I am the employer of the deceased Niranjan Mondal. That the deceased Niranjan Mondal was attached to my aforesaid vehicle in the capacity of Khalashi for last 1 year prior to his death. And he used to receive rupees 2,500 per month as his salary. That I came to learn that on 8/9/2010, the said deceased met with an accident and died on the same day. That I have not received any summons from the end of the learned court, but on the request of the petitioners of the deceased, I have come before this learned court to depose in connection with the above noted case, as I was the employer of the deceased. Subhash. This is
Yes.
typographical. Now, my lord,
This is the examination in chief.
yes. Next page 19. I have filed my examination in chief of affidavit. I have signed the affidavit. I issued this certificate. He has issued a salary certificate or whatever. It is showing the income of the victim. This is the said certificate, exhibit 9. Cross examination is, my lord, see, I have not brought any ID card today. A person coming before the learned tribunal, before court, without any ID card. Who is he? I am a owner of a truck. I have brought blue book of the said vehicle. I brought this vehicle in 1995. The certificate of fitness was not valid up to 23/5/2000. Niranjan was an employee of my vehicle prior to the occurrence of the alleged incident, not a fact that I was not the owner of the offending vehicle at the time of the motor accident, not a fact that I issued a false certificate as the victim and his family members are known to me. I did not maintain any register of payment to my employees. Generally, Khalashis are given salary in the margin of 2,500 to 3,000. My lord, please come to the judgment. Page 23. My lord, have got it? Last paragraph. The claimants have further stated that at the time of alleged motor accident, the deceased was working as a khalasi in a truck bearing number such and such. PW1, the wife of the deceased, has stated in her evidence that the deceased would earn rupees 2,500 per month as a salary from the owner of vehicle number WP732371 to substantiate the contention of the claimant.
You are reading paragraph,
Last paragraph, my lord, page 23, judgment page
last,
4.
last paragraph.
Last paragraph.
Yes.
Will I read it again, my lord?
Yes. No. We just continue.
To substantiate contention of the claimants, they have examined PW3, Soumitra Karmakar, who has claimed himself as owner of truck number WP732371, in which the deceased used to work as Khalashi. This PW3 has stated in his evidence that the deceased Niranjan Mondal was working as a Khalashi at the time of alleged motor accident, and he used to pay a sum of rupees 2,500 per month as his salary. However, this PW3 has not brought any payment register to substantiate the contention that he used to pay rupees 2,000 per month to the deceased Niranjan Mondal. Apart from this, his evidence is also not sufficient to say that this deceased was working as a Khalashi in his truck bearing number such and such. As a matter of fact, the claimants also have not filed any documentary evidence to substantiate that this PW3 is the owner of the vehicle number WP732371. It is fact that in his cross-examination, this PW3 has stated that he brought the blue book of the said vehicle, but surprisingly, the said was not proved or marked by the learned lawyer for the claimants. The reason is best known to the claimants themselves. Apart from this, his cross-examination shows that the certificate of fitness of the vehicle bearing number WB73237 was valid up to 23/5/2000. However, the alleged accident took place in the year 2010. As such, the evidence adduced by this PW3 is not worthy to be believed. In such circumstances, the contention of the claimants that the deceased was a Khalashi of vehicle number WB732371 and would earn rupees 2,500 per month cannot be believed. However, it is clear from the petition and evidence emanated from the mouth of the witnesses that the deceased was an able-bodied person, as there is no sufficient evidence to prove in the occupation and income of the deceased. The notional income of 18,000 per month can be taken for calculation. So, by applying structured formula, that is, this is the reason the learned tribunal did not believe the income of the deceased. And my lord, please come to page 47. No, this is the vehicle involved in the accident. They have not filed 2371. Blue book has not been filed. This is a registration certificate page. Registration certificate of the vehicle involved.
Offending
in
vehicle.
Certificate to the offending.
Offending.
of the offending vehicle. And my lord, the interest point, it would be 6%. If any enhancement is there, my submission is that there will be no enhancement. The learned tribunal has aptly taken the income,
Yes.
and there will be no enhancement. And multiplier is also okay according to the
Multiplier. How multiplier is okay?
get account.
Beyond the structure formula and beyond Sarala Verma.
My lord, please come to the structured formula. My lord, have except for the PM report, my lord, there is no iota of paper documents to prove what was his age. So 40 years, but not exceeding 45, it is 15. So 15 would be correct. My submission.
So 11 is not correct. The learned tribunal adopted the multiplier as 11. Your submission, it would be 15. Yes.
My lord, please come to page 24 of the judgment.
Yes.
Last part of the big paragraph, my lord, see, as there is no sufficient evidence to prove the occupation and income of the deceased, the notional income of rupees 1,800 per month can be taken for calculation of the compensation. So by applying for a structured formula, the amount comes to 1,98,000.
18,000 is multiplied by 11. That's why 198,000 appears.
My submission, my lord, kindly. My submission will be whatever the learned tribunal has taken is correct. But according to law, it would be 15. That is not my submission.
Anything?
And interest will be 6% for that one.
Very good. Hard.
I'm ready.
Please take down. The instant appeal is preferred against the judgment and award dated 26/8/2011 passed by the Judge Motor Accident Claim Tribunal, First Court Jalpaiguri, in MSC case number 273 of 2010 under section 163A of MBA. Stop. The claimants are appellants here. Stop. The brief fact of the case is that on 8/9/2010 at about 10 a.m., the predecessor of the claimant, namely Niranjan Mondal, within bracket deceased, was going to catch a rickshaw at Station Road near Jalpaiguri, and at the time, one Maruti van bearing registration number WB72/D 2317 dashed the said deceased. As a result, he sustained injuries in his person and admitted to Jalpaiguri SD hospital. However, the attending doctor declared the said deceased to be brought dead. It is the case of the claimant that stopped the decline. At the time of accident, the deceased was Khalasi of track number WB732371 and used to earn rupees 2,500 per month as his salary. So the legal heirs of the deceased claimed for just and proper compensation. The insurance company contested the case by filing written statement. Stop. During the trial, the claimant has produced 3 witnesses who deposed before the learned tribunal, but no witnesses were produced on behalf of the insurance company. Stop. Several documents, including police papers and PM, were produced and exhibited before the learned tribunal. Stop. Next part. After hearing the parties and after considering the materials and record, both oral and documentary, learned tribunal has awarded a sum of rupees 1,32,000 to be the just and proper compensation in this case. The appellant's claimants are here for enhancement of the award. Stop. Learned advocate for the appellant briefly submitted before this court that there are only 4 points to be considered in this appeal. Firstly, the income of the deceased was assessed by the learned tribunal notionally to be rupees 18,000 per annum, which is totally improper. He submitted to this court that PW3, that is the employer of the deceased, appeared before the learned tribunal and submitted that he used to provide the deceased rupees 2,500 per month as a Khalasi office driver. Khalasi of his truck. Stop. Khalasi of his truck. Stop. He further argued that the learned tribunal has disbelieved the statement of the PWC without any cause and reason. Thus, full stop. Thus, it is the submission of the learned advocate to the appellant that in this case, for assessing just and proper compensation, the income of the deceased should be calculated at the rate of rupees 2,500 per month at least. He also argued that by virtue of judgments and the view of this honorable court in several cases where the accident was happened in the year 2010 or prior to that, the monthly income of the deceased should be notionally calculated without any proper proof of document to be rupees 3,000 per month. Stop. Learned advocate for the appellant also submitted that the multiplier adopted by the tribunal in this case is 11, which is erroneous as per the structure formula according to the provision under section 163A of the NDA. They also submitted that the general damages of rupees 9,500 was also not given in this case, and the interest was not calculated along with the awarded sum. Learned advocate for the insurance company raised strong objection and submitted notice court that the insurance company has contested the case by filing a statement. She firstly pointed out that the claimants has failed to prove the income of the deceased before the learned tribunal. The learned tribunal disbelieved the statement of PW3, and the reason thereof has been specifically noted in the judgment itself. Within bracket page 24 of the paper book. Bracket close. He further pointed out that the evidence of PW3 cannot be believed as no document of his ownership or his identity were produced before the learned tribunal. He further submitted that the multiplier should be adopted according to the structured formula under section 163A of the NDA Act, and if the awarded amount shall carry 6% interest per annum. For the learned advocate, peruse the materials on record. It appears to me that the income of the deceased was notionally calculated by the learned tribunal to be rupees 18,000 per annum. Stop. The claim application stated the income of the deceased to be rupees 2,500 per month, and occupation was stated to be khalasi of a truck bearing number 73 WB73 stroke 2371. The PW1 has corroborated the claim application to that score, and PW3 appeared before the learned tribunal to be the owner of a vehicle bearing number WB732371. PW3 filed his written examination in chief on affidavit before this court, before the learned tribunal. Examination in chief on affidavit before the learned tribunal. In the cross examination, he stated that he has brought the blue book of the vehicle, but it was not filed. Learned tribunal has disbelieved the PW3 on the ground that the blue book was not filed before the tribunal. In considering the submission of the insurance company, it appears that insurance company did not produce any oral or documented evidences to disprove the income of the deceased. Only they pleaded on the basis of the cross-examination of PwC. Learned Tribunal also acted on the submission of the insurance company. The division bench of this court in Mita Samanta has specifically guided that while the insurance company has filed the written statement and taken the leave under section 170 of MDA under section 170 of MBA to contest the case on all reasonable grounds, on available grounds, but they did not produce any oral or documentary evidences on that scope. The claim of insurance company regarding the income of the deceased cannot be entertained. Furthermore, it appears to me that the claim of the claimants regarding the income of the deceased was duly corroborated by adducing two oral evidences, that is PW1 and PW3. Two oral evidences, that is PW1 and PW3. In this instant case, there are specific evidence regarding the fact that the deceased used to earn rupees 2,500 as khalasi. I find there is no merit to disbelieve the fact on that score. The observation of the Learned Tribunal regarding the income of the deceased is erroneous. Considering the just and proper compensation of this case, it appears to me that the Learned Tribunal has committed error in awarding the compensation in favor of the claimants. Thus, the impugned order and judgment passed by the Learned Tribunal is hereby modified hereunder. Hereby modified as follows. Next, the income of the deceased is taken to be 2,500 per month. Thus, yearly income comes to rupees 30,000. Give me the structure.
Tab, prepared one.
Three lakh. Yearly income 3 lakh. Yes. Yearly income comes to rupees 3 lakh. 1/3 of his yearly income be deducted towards his personal expenses if he had been alive. Accordingly, the yearly dependency comes to rupees 2 lakh. Sorry. That 30,000.
20,000, so
20,000.
20,500. 30,000.
30,000 is yearly income.
130 lakh 10,000. So 20,000 is
20,000. Okay. 20,000. Okay. Expenses if he had been alive. Thus, yearly dependency comes to rupees 20,000. 20,000. The applicable multiplier of this case would be 15 according to the structure formula, considering the age of the deceased to be 40. Thus, after multiplying the multiplier with the yearly dependency, the award comes to rupees 3 lakh. Stop. The claimants are also entitled to get an amount of rupees 9,500 towards the general limits. After adding all the head, the award comes to rupees 3,09,500. Tribunal has already awarded a sum of rupees 1,32,000. So the balance
1,77,500.
would be 1,00,000.
77,500. 3,09,000.
Yes, 1,77,500. 500.
See, interest on that amount, 1,32,000 and interest of this amount. Yours.
No, in usually I award interest on the balance amount. Have you received the amount?
You'll receive
Yes,
only
we have.
1,32,000.
Yes, you have
So
received
the
your
interest on
amount that can carry the interest, everything is there. So the balance amount shall carry 6% interest per annum. 77,500. Stop. The insurance company is directed to pay the balance amount to the claimants along with 6% interest per annum through the London Register General, Calcutta High Court, within 8 weeks from the date of passing of this order. Stop. The claimants shall receive the award from the Office of the London Register General, Calcutta High Court, upon proper identification and verification according to the law. Stop. The payment is disposed of. Granted time application also disposed of.
I'm grateful, man.
Yesterday, one matter was taken up, family members. I am for the appellate insurance company, Mr. Motor. Half of that individual gentleman, Suresh Sharma, that matter.
Yes.
Yesterday, your lordship had passed an order, 16th, 18th of July. And last chance to prepare paper, the media. I had earlier occasion, I had applied for certified copy of all the documents. There was 3-4 days time, my clerk missed that after making application. After 3-4 days was given, again file came back to your lordship. So it lapsed. I have again made an application on 30th of June. File needs to go back.
Yes. What is the number?
Number I will give it to your lordship. Send back immediately.
Okay, that's fine.
So that would again.
Yes.
I'm good. I'm good.
Yes, today up to 3:30.
Man.
আজকে দাবি দেবেন তাহলে কাল